Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, everyone. Oh, hang on. Good girl. There's a good girl. All right, guys, we are here. We are ready. Welcome to day 31 of the Karen Reed murder. Look at that slow zoom into Indy's face. That's great. I love that. I have no control over that zoom. I don't know why it's doing it, or but this is like it has a mind of its own, this thing. But all right, but welcome to day 31 of the Karen Reed trial. This is the final day before it's just straight deliberations and then verdict. We are here strictly for the closing arguments today. So welcome back. Welcome back. Welcome back. This has been quite a journey. Thank you so much for joining me on this journey. It's been quite a wild ride, right? Mr. Toad's Wild Ride has got nothing on the Karen Reed trial. Okay, so they just started the feed, like active feed for the courtroom. So let's jump right on in. And we're just gonna get going with it. So we do have a poll in the chat. This time it's just two options because there's no more time for more information, right? All of the information you're gonna Indy. All the information you're going to get in this trial is information that's already there. So no time for more information. It's either guilty or not guilty. And yes, because we have been, it's been a long trial. I see it in the chat.
It's been 84 years.
It does. It does feel like it's been 84 years. I think it literally has been. I may not have even been pregnant when we started this yet. I'm kidding. And Dayan Luich, thank you so much for the super chat. Hello, beautiful people. Has it been 84 years? Yeah, it definitely feels like it has been. Let me get just a few questions here. Actually, before we get started. Evil Bunny 7603 question: do you think the Lally went home at night and watched YouTube and TikTok? He probably wanted to stay away from everything, I would imagine. Sue B question: I'm used to not guilty then guilty being on top of the poll. Hit the wrong thing from the look of it. Others have done the same. I wonder what reasons people have for actually choosing guilty. No, I've always done guilty and then not guilty first guilty and then not guilty second. So I don't know. At least that's how I've always typed it in. I don't know if YouTube changed that on like this poll because there's only two options as opposed to three. But I mean, currently it's saying 97% not guilty, 3% guilty. And also, shout out to the folks who think that Karen Reed is guilty and are still hanging with us, because this is a majority not guilty chat. I've been very clear about how I have been feeling with the with the evidence here as we've been progressing, as I've been getting convinced. And for me, it's been leaning me more and more towards the defense. So shout out to everyone who is disagreeing with the majority here, but still hanging with us for the ride. I really appreciate that too. That is awesome. Awesome to see. Walt Dog 5791 Legalbytes. Next poll should be: how long do you think the jury will deliberate? Yes, that definitely will be, because that is going to be an interesting question too. And Hussar 1683, thanks for the super chat. No matter what, it's been a hell of a ride, good folks. Absolutely, totally agree. DeMajor LDN Legalbytes was the final tally. Presumably he can't do it in closing, right? Yeah, he can't do it in closing. Dang it. Okay, let me take a look here, because I still have to modify it for who said what on days 29 and then day 30. So day 29, there were a total of 19 what if any's, but I know that not all of those were Lally. So there were 19 on day 29. And then on day 30, there were 5. I know that at least 2 of those were Lally's, but I can't confirm that all 5 of them were. So we have those numbers, but I want to go through. I want to sit down and go through the transcript and actually like parse out what was Lally's and what was not his. So that's not quite the final number. That's like the reserve final number is another 24 on top of 2000 on top of 1993. So 90, somebody can math. So so 2017, I think. 2017 is the current number with an asterisk. It's going to change most likely. Okay. All right, guys. Let's the rest of the questions I am going to save in the chat, and we're just going to get right into it. Okay. Let's do it.
All right. I need to see counsel.
Oh, okay. Well, there was a sidebar anyway. Okay, let me make sure that I've got all the questions in here. I apologize if there are questions that I've been missing here. Okay. So, we're going to fast forward through this sidebar here. Okay. How ready do you think Karen Reed is to be done with this trial, assuming that it ends in an acquittal, right? I mean, otherwise oh no, it's a much longer sidebar. It seems like. Are we back to the spinny fan? I guess we're back to the spinny fan. All right, so let's go through more questions then. Okay, okay, sorry. I am also trying to capture these new questions here as well. Okay. Sophie, question. Others have probably asked this, but will there be another investigation after this trial if she's concluded not guilty? What's most likely to happen? I mean, there is a federal investigation into this case. I don't know what the extent of it is actually going to be. But you know, I think that's regardless of whether she's innocent or guilty, regardless of the jury verdict, there is an active investigation. I don't know too many details about it. I haven't looked into like most of the side issues around this trial. For me, it's been primarily about this case or you know what, maybe we'll do it like this since Cindy's not in the chair. For me, it's been primarily about this case, this trial, the facts of this particular trial right here. So yeah. And I'm just keeping the fan on screen so that you guys can see when it does shift away from it. As XMO, hello Legalbytes. What is your honest opinion of the performance of Judge Cannone? I think she was consistent and reasonable throughout the trial, and I like her ask it differently. I mean, to me, there were some things that frustrated me in some of her rulings. Some of them I was satisfied with. Like to me, it was an obvious answer for that, you know, that DUI lawyer search that the prosecution wanted to bring into the to bring in front of the jury. And that was a correct decision, in my opinion, for her to say, no, you can't bring that in. It's more prejudicial than it is probative, probably because it's exclusively prejudicial and not at all probative. But yeah, Stella by the Sea, thanks so much for the super sticker with a coffee that says tired. I feel it too. This has been such a wild ride. You know, it's been such a great ride. Thank you again for all of you for joining me on this ride. It also is exhausting, especially when you're doing all of the live streams plus daily recaps of all of this stuff. And I've also been working with a new editor too, who we've been sort of figuring out like how to best work together. And with like this sort of working arrangement that we've got going on. And, you know, anytime you're getting used to working with a new person, there's always kinks to work out. So, you know, anyway, but not a complaint at all. All of it has been awesome. It's just, it'll be nice to have a little bit of a break. And actually to that effect, it's not going to be too much of a break because, well, it'll be a lighter workload for a little bit because we're going to be putting out more content that's on more, you know, other topics. There's some things that have been coming up that I've been wanting to talk about, but I've been so busy with this trial that I haven't been able to get to them. So there will be some uploads that I'll be putting out as well, and other stuff too. And we've got more trials to look forward to. We've got the Alec Baldwin trial that it starts, I think, maybe like July 9th. And I just saw yesterday that there was coming out of the hearing, the judge said that it was really going to last at most like 7 trial days or something. So that's like a week and a half, 2 weeks, something like that. So it's going to be a much shorter trial, but it's going to be early July. And she said that it's absolutely not going to go past the 19th, which is also good because there's another trial coming up out of Florida on July 22nd or the 29th. I've got to double check. It's like one of those 2 dates was an option last I looked. That is the Ashley Benefield trial, also known as the Black Swan murder trial. She's on trial for murder for killing her husband. She says it was self-defense. The state says otherwise. So interesting stuff that's going to be coming up on the trial, on the case, or on the channel as well, with other trials and whatnot. But it does, it'll be nice to sort of fill that space in between with other content too that is also very, very interesting. So definitely stick around for all of that stuff as well. But yes, thanks for the super sticker, Stella by the Sea. So, okay. So, but I guess, back to the performance of Judge Cannone. I think overall, a lot of the complaints that a lot of people have had with her use of, I'll allow it versus overruled, to me, that doesn't, it's a bit of a nothing burger, because she applied that evenly across the board from what I could tell. So she used that a lot, but that just seems to be a Bevism, right? It's just one of those things that she tends to say quite a bit. And, so long as she uses it evenly, that's what I care about most, is she's not prejudicing one side or another with that. So I think overall, like for the most part, I really have few complaints. It's just a few things here and there that have been a little like, I don't know. I disagree with that one. And Wings, thanks for the super chat. Hey, Alita, if you were a jury member, how would you feel about CW/Lally for bringing this case / wasting a month of your life with a lot of this testimony? If I were on the jury, I mean, if it were me currently, like not me, like as one of those other individuals, obviously it would have to be me with my brain and my experience and whatnot. Oh, that's interesting. Sorry, I'm going to interrupt this real quick. Hang on. No, this, and take that off. No. Okay, sorry. It just said, we're going to go back. Karen Reed is leaning to try to hear. Remember, this courtroom is tiny. Juror is leaving the courtroom. So there's maybe another juror who is leaving. That's interesting. That's very interesting. Okay, sorry. Back to N-Wings. So if it were me with my brain currently, I would be mad. Yeah, I'd be like, there's so much wasted time. I would be. Yeah. I definitely would be. Honest Mike, question. If somehow she's found guilty, what do you think is next? Enough bias for a reasonable appeal? Could the Mudge overrule? Seems silly to even suggest, but legally possible, right? The likelihood of Bev overruling is incredibly low. Judge Cannone is very much not likely to be overruling trying to supersede the determinations of the jury, because I've said this before and I'll say it again. I'll say it until I'm blue in the face, essentially, that the jury system is very much favored. The decisions by the jury, in order for them to be overturned in any kind of a way, there has to be some sort of a very, very, very strong reason for it. It can't just be they came to the wrong conclusion. We don't like that in our American judicial system. So otherwise, though, next would be appeals by the defense team. There are a number of decisions here that I think they would have some room for some decent argument. Whether or not they would win, it's the likelihood of winning on an appeal is always pretty low, pretty dang low. So the hope for any criminal case defendant is always an acquittal above all else. Alex025, thanks for the super chat. My only other trial I watched was the Johnny Depp, as this judge is her opposite. Yeah, she's definitely different from Judge Oscarati. She is, for sure. I love Judge Oscarati. I had zero complaints about her. I think she ran a very efficient courtroom. I think that there was nothing that she ever did that indicated any sort of bias or leaning or anything like that. And I don't remember even disagreeing with any of her decisions, to be honest with you. Joseph Zalay, thanks for the super chat. Who paid expert witnesses from yesterday, if not CW or the defense? Were they subpoenaed and required to testify for free? Love your channel. Thank you. Thank you so much. And you're welcome. Thank you for being here. So I think that it's the Department of Justice who's been paying them. If they weren't even paid to be there on that day during their testimony, that was actually even more interesting to me too. I don't know the answer to that question, unfortunately. It would be interesting to find out. I doubt we'll ever find out. But maybe they volunteered it, or maybe the DOJ said, like, we'll pay those fees for you guys to go. I don't know. Either of those is possible, but it is an interesting question. It's a bit intriguing. And I'm sorry I don't have the answer. Dejan Lujic question. Will we hear the jury instruction on live? Oh, yes. Yes, we will. We definitely will. Because this is what they do is they always read the instructions to the jury in the courtroom, because that ensures that no juror can come back and be like, well, I never saw the jury instructions, so therefore, if there's ever some kind of an issue where there's some kind of a question about the choices by the jury or the decisions by the jury, and then like someone says, like, I never heard the jury instructions, so I didn't have to follow them because I didn't even know that they existed. If everyone's sitting in the courtroom and they're forced to listen to them together, it's on the record that everyone heard those, and therefore they have to abide by them. So, and then they're also going to get them written as well. They'll get written copies as well. Okay. Let me get some of these questions here as well. Make sure I'm saving as many of these as possible. Wingy158 question. Is there a tally for sidebar? There is no tally for sidebar. I started one for sort of. I also started one for, I have a whole Excel spreadsheet actually that I started to put together. And maybe I'll do that over the next like day or so, is like kind of sit and just sort of do that when I finally have like some other content on the TV that has nothing to do with this trial. I might do that. Then come out with some interesting numbers for those. So it's sorta, and then maybe it was as far as, or something like that. I can't remember. I've got to look back at the sheet, but I was definitely doing the numbers on one of my flights for a couple of those other Lally-isms as well. Brittany Chanel, Legalbytes, I think she's not guilty, but I think the jury will find her guilty just for the hell of it. I mean, you never know. You never know what the jury's going to do. However, I do think that for the most part, juries make a decision based on what they think is right, especially when they've been forced to sit there for such a long time. They know that there's important stakes at play here, right? There's the defendant's rights. There's also the victim and the victim's family. So, I don't really necessarily agree that the jury is going to just be very willy-nilly about this decision. They tend to take the job very seriously once they are seated. So I have a feeling that most likely the jury is going to sit there and try to actually come to a legitimate conclusion that they can feel good about. Because at the end of the day, they are turning to the defendant and telling them potentially, I'm going to put you away for life, or telling, the family, this person that the state says killed your son is going to go free. They have to be able to look at both of them in either scenario and say, we've made the right decision. So in order for them to do that, that typically requires a bit more circumspection and a bit more thought going into it. So I really don't think that, usually I think that that jurors and the jury in general, I think that they do tend to take that very seriously. Nihilist Craig, Legalbytes, what should Lally's closing argument focus on? If I'm the prosecution and I'm taking this big this big turd and trying to polish it for the jury, I'm focusing on Karen Read's words, allegedly. I put that in quotations because that's disputed, right? Whether or not she actually said it, whether or not it means what they say it means, that is disputed between the two sides. If I'm the prosecution, I am going to focus in really hard on so-and-so heard her say this, so-and-so heard her say this, so-and-so heard her say this. She said, I hit him, I hit him, I hit him. And this is what this indicates. And this is like these voicemails here indicate that she has this level of hatred for him. And, that is a level of hatred that is indicative of, what what a murderer would say or something along those lines. Like that's, I think, where the focus probably should be. Now, what I think is going to happen on his closing argument is there's going to be a lot of spaghetti thrown on the wall. And I don't know if it's going to be terribly organized. Maybe he's going to surprise us all, right? Because maybe he'll say, okay, haha, gotcha. You all thought that I was setting this pattern and I was going to continue the pattern of boring everyone to death and not really having much organization to all of this. But guess what? When it really, really matters, I'm going to surprise everyone by putting together a very compelling closing argument, and it's going to be super well organized, and you'll see exactly what I'm talking about. I don't know. That could happen. The fact that he's been this way up to now isn't necessarily an indication that that's how it's going to be moving forward. I don't know. We'll see. It'll be interesting either way. Greg Vincent question, any guesstimate as to the overall cost for Karen's defense? Easily hundreds of thousands of dollars, upwards towards $1 million, maybe more than $1 million, maybe several million. It's hard to tell because it's hard to tell because I don't know what their legal reason their hourly rates are for these attorneys. I haven't seen anything about that, in any sort of filings or anything like that. I haven't looked for it. But I would imagine with the level of experience that both Yannetti and Jackson have, and Elizabeth Little too. She is, by the way, we've always kind of looked at her as like the junior person on this team, but she is a partner at Jackson's firm. So she's not a named partner, but she is a partner, which means that she's been litigating cases long enough and with enough experience, and she's done well enough at the firm that they offered her a partnership in the firm. So that is a that's very telling of her experience and whatnot. So, all three of these people who have been there day in and day out at this trial. And by the way, there's also more hours at the end of the day after these trial days are over. It's like the cameras go off, but for them, there's still work that's continuing. It is perpetual during a trial. They're exhausted by now. They certainly need a break. And even on the weekends, there's probably more stuff that they need to go over, stuff from transcripts, and you need to make sure that they got certain things in so that they can add that to the closing arguments. You've got somebody behind the scenes that is helping to prep a closing argument while trial is happening, as it's going on. There is so much work that is being done behind the scenes. There's also exhibits. There's stuff that they have been so smooth. And that is an indication of a lot of prep work behind the scenes that we will never see. It's trial really is a glacier. It's a massive glacier. We see the top of the glacier, above the water, but most of the work is stuff that the jury never sees, stuff that we don't see on camera, anything like that. So yeah. So in terms of like how much, I can easily see it being several million by the end of this trial, because of the years of how much work has gone into it and all of the publicity and the hearings and just everything. I can totally see that. Okay, let me make sure I've got these. Okay. John Henderson, thanks for the question. What are the other charges and what do you think the verdict will be? So, of course, we've been talking about second-degree murder. Well, we've been talking about murder in general, but it's second-degree murder is the first charge here. Then there's also yesterday, when we were watching the charging conference, that was when they were going over the jury instructions or the proposed jury instructions and basically like kind of parsing through them, what they were going to end up doing. I mentioned yesterday during the live stream, it was the DUI charge. It's not really a DUI charge. It's a DUI manslaughter charge, meaning that she committed manslaughter while being under the influence of alcohol. And, oh, did I get super grainy? Probably because of one second. Oh, not too bad. Okay. Kind of. Okay. Anyway, okay, it's resolved. Anyway, so it's manslaughter while operating under the influence of alcohol or drugs. And so actually at this point, let me go through the charges and the possible sentencing, like what she's looking at in terms of like years in prison and things like that. So for the first one, second degree murder, that's 15 years to life. That's potentially life in prison, minimum of 15 years. Manslaughter while operating under the influence of alcohol or drugs, there's still intent involved in manslaughter, even though it's not murder, it's manslaughter. They have to show, prosecution has to show that she intended to kill the victim, or she intended to cause grievous bodily harm, or that she should have known that her act would lead to a strong likelihood of death, and that she did in fact kill him unlawfully. When it says killing someone unlawfully, it's not like, yeah, it sounds a little silly, but the reason why they say that is because there are some affirmative defenses. There are some lawful killings, for example, self-defense, defense of others, things like that. So for manslaughter while operating under the influence of alcohol or drugs, she's looking at 5 to 20 years in prison and a fine of $25,000. Then the third charge is leaving the scene of personal injury and death. And there's two options for that. Either 2.5 to 10 years in state prison with a fine of $1,000 to $5,000, or 1 to 2.5 years in jail or house of correction with a fine of $1,000 to $5,000. So all of those still hinge on whether or not she hit him. If the jury cannot determine that she actually hit him, they can't hang their hat on that. Oh, here's from Court TV. I don't know if you guys can see it at that font. Court Insider. We still don't know what is going on. No decisions have been announced about the juror. I really hope that this is not a last minute like thing that just like suddenly causes a mistrial at the very end. That would be insane. Yeah, that would be pretty nuts. Okay. I want to make sure that I've got these. So yeah, so those are the charges. Those are the three charges, and the possibility of of like the years in prison that she's looking at for all of these. And all of those, like I said, they all hinge on whether or not she actually hit him. So, the Google searches, the voicemails, all of that other stuff can be tossed by the wayside if the jury just says, I don't know that I can say that she hit him. Jonathan Willig, question. If she is found guilty on any charges, can the judge throw out that conviction, or does it have to go to appeal? There's too much reasonable doubt for a conviction on any charge. I definitely understand what you mean, and I agree. I think that there's way too much reasonable doubt, but the judge generally can't toss that out just for nothing. So there has to be a good reason for tossing out a jury verdict. This is interesting. Hazawan, thanks for this. From updates on X and from inside the courtroom, one juror came in briefly before the rest had been seated. They met at sidebar and then left the room, unsure of the issue. Interesting. Okay. That's very interesting. Okay, let me try to get these other questions here. Alex025, thanks for the super chat. Will anything happen to the police after the trial? I don't know. The likelihood of that, There's got to be political will. There's got to be like all kinds of public outrage. But I don't know if anything will happen to the police after the trial. Mark Smith, member for 1 month. Thank you so much for being a member here in Bite Club. Thank you for the great coverage. Also, puppies rule. Thank you so much. I appreciate that. And yes, I agree. Puppies do, in fact, rule. Okay. All right. KJ Height. Legalbytes question. Did you know it's going to be defense closing and then prosecution closing? I forgot that they had mentioned that yesterday during the hearing. It's such a weird thing that it like didn't stick in my brain, but I saw people talking about that, and that reminded me that yes, they did in fact say that yesterday, which is, it's weird. This trial has been so weird in so many ways, and this is just one of them.
Court's back in session. You may be seated.
Court's back in session. Okay. Or is it? Okay, no. So now it's like an actual sidebar. Deanna Spencer. Sorry. Thank you for the super chat. Why are the Alberta McCabe's in the courtroom? Oh, the Alberts and McCabe's. Do we think this will have an impact on the jury during closing arguments? Love your stream. Thank you so much. I appreciate that. I don't know why they're in the courtroom. Maybe because they decided that they really want to be there. Can it have an impact on the jury? I mean, they've already seen them. They've made up their minds about these people. So I don't see that becoming really a thing for impacting the jury. I don't think their presence really should have any kind of an impact on the jury, because they've already been. It's not uncommon for witnesses to come back at some point during the closing arguments and sit in on those as well. We'll see how they react when, the defense does their closing argument, though. That's going to be interesting, is to see, can they keep a straight face, or are they going to start looking very sour? All right. KJ Height, Legalbytes, did you know? Oh, yeah, sorry. We already got that. Honest Mike, who do you think should play the main characters in the movie? Sandra Bullock as Karen, Philip Seymour Hoffman as B.A. Well, unfortunately, Philip Seymour Hoffman can't play anyone at this point, right? Didn't he pass away a few years ago? But yeah, I could see Sandra Bullock as Karen Reed. If she can do a good Boston accent, sure. Yeah. Yeah, I think those are great options. AJ187, Legalbytes, how long does it take to give a verdict? All my knowledge is from movie 12 Angry Men. It can take hours, it can take days, it can take, over a week, potentially. I mean, this trial has been very long. It's very complex. I would imagine that the jury has a lot to talk about. So that's, I would not be surprised if it took a day or two. Fairly easily a day or two. Has another update from Fall River reporter on X. The press has been talking, but they still don't know what's going on. Judge left the room and is back in sidebar. Okay. So then I wonder if that's just, I don't know. She must be dealing with some kind of a juror issue, and now she's relaying the issue to the attorneys. So maybe someone had to go home or something. I don't know. AG187. Oh, we already got that one. Dayan Luich question: since you'll be covering Alec Baldwin trial, could you give a short summary of what's the case about? It's been a while since the events happened. Yes. So Alec Baldwin was on the set of, we'll do it like this. Alec Baldwin was on the set of the film Rust. It was an indie film in New Mexico. That's where they were on location to shoot the film. And there was a shooting on set. And that bullet came from the revolver that was in the hands of Alec Baldwin. Now, live rounds typically are not supposed to be on set. So there were naturally a lot of questions about this. There is an armorer on set who works in the prop department who is supposed to be managing all of the firearms and making sure that there is safety on the set with any kind of dangerous items having to do with props. Explosions and stuff is a separate department, is my understanding. However, any firearms are under her control. That armorer is named Hannah Gutierrez Reed. She already had her trial in like late February, early March. That was her trial. She was convicted of involuntary manslaughter. Alec Baldwin is also on trial for involuntary manslaughter, the same thing. What he's looking at is at most 18 months in prison. New Mexico is a little bit strange with that, even though it involves a death, even though it's manslaughter. 18 months is not really that much. In comparison, if you followed the trial of the Crumbley parents, Ethan Crumbley, the Oxford school shooter. So he's a teenager who shot up his high school. He got access to firearms that were in the home. Well, his parents actually gifted him a firearm in the home when he was underage and all this kind of stuff, knew that he had all kinds of mental health issues and whatnot. Both of the parents were convicted of involuntary manslaughter, and they are serving I can't remember. I think it's like 15 years or something like that. Difference between Michigan and New Mexico. So the state that you're in can have a huge impact. Alec Baldwin, on the other hand, is facing like 18 months. So there's the involuntary manslaughter charge, which basically means he didn't intend to kill anyone. There's no intent to actually cause anyone harm, but he did something. Or he acted recklessly, more or less, with this very dangerous thing. He knew that there was a danger. He should have known that what he was doing was wrong, and that, in the process, he ended up getting someone killed, and that therefore he should spend time in prison. That's the basics of the argument here. Now, the thing that's been very interesting between the two cases is because there's like this chain of custody of all of these props and of the ammunition and dummy rounds and blanks and things like that, live rounds. There's a bit of complexity as to like what kinds of rounds are used for different things, and do they have any place to be on set, and or being handled at all by anyone related to the film production. Interesting stuff. But there also is the capability of saying, it wasn't me, it was them. It was their responsibility, not mine. And the armorer, quite rightly, has a lot of responsibility here because of the fact that they're the ones that manage the safety of the firearms on set. Now, Alec Baldwin, as I said, he's the one that had the revolver in his hand. So at the end of the day, he also bears some level of responsibility. The question is, does he bear criminal responsibility? So that's what the trial is basically going to be about. He's got some extensive history. People will say he's just an actor. He also was a producer on film. The state seems to suggest that his producer role gave him some extra responsibility. So we'll see about those details that'll come in at trial. But also, he has a lot of experience using firearms on set. And so I would imagine that his training and experience with firearms from previous movie sets and previous TV show sets. Oh my gosh, we're back at sidebar. Okay, back with the spinny fan. So anyway, I was going to say, I would imagine that based on all of his years and years, decades even, of experience, I think he's handled the firearm on set like 21 times before Rust. That's what I think I remember researching. Oh, and here's what it says on the screen. Court Insider appears that the CW is making an argument about this juror, Laura McLaughlin, Assistant District Attorney, Norfolk County. But what kind of argument? To keep her or him, or to not? Judge is reading from a book. Reed is once again leaning forward, arms crossed. Yannetti is arguing. Interesting. This is very interesting. So, anyway, maybe that was a little bit more of a summary than what you were looking for, Dan. But that's the basics. It was a cinematographer who was killed on set. The bullet passed through her, and then it ended up in the shoulder of the director, Joel Souza. So, yeah, so he was injured. He was able to testify and all that kind of good stuff. But yeah, it's an interesting case for sure. And it'll be very interesting to see what happens with that case. Also, Phantom Split, thanks for this. Sue O'Connell saying that this juror is back in the courtroom, but not in the juror box. So there's some kind of an issue, I think, going on here with this particular juror. Interesting. Okay. Moving on down. AG 187. How long does it take to give a verdict? Oh, we already answered that one. Nathan Gross, question. Do you think she's still this far ahead if the Proctor texts weren't let in? I thought it was a big deal until Trooper Paul. I thought so too. I thought we were like done with all those big twists once we got through Trooper Proctor. I'm like, nothing else is going to come up to top this. But then, Trooper Paul testified and all kinds of interesting stuff came out with his testimony. XMO, Legalbytes, do you think Lally was pressured to take this case to trial? Do you see him resigning after a not guilty verdict, and how can this affect his career? At the very least, he does have high profile trial experience at the end of all of this. So that is something that he can always walk away with is having learned something through this whole experience. Whether that is like the good kind of lesson that you can feel good about, or like tough lessons, either way, there's stuff that can be learned by any attorney watching these proceedings or going through these proceedings. I think that for his part, he can definitely walk through this experience and say, I have tried a high profile case. It was tough and I ended up winning or losing or what have you, but here's what I learned. I think, whether he would resign, I don't know. I mean, that's entirely, speculative into his brain. I don't know where he would be feeling about his career or his positioning or what he wants to do with his career at this point after this case. I mean, but sure, I could see someone in his position resigning or continuing on and doing other cases after this. Buttercup 203 question: why did Bev limit closings to 1 hour? Is she going to set a timer? Well, because it's best to give some kind of a time limit here. I think 1 hour is plenty of time for both of these cases. If you allow Lally to go longer than an hour, like, I mean, I just don't see. Look, it's a complicated case, but it's not that complicated at the end of the day. Because, especially it shouldn't be that complicated for Lally's side, for the prosecution, because it should be, this is the simple narrative. It's a very simple case, very straightforward. This is what happened. Boom, 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 boom. You've got the fact that she drank the night before and her BAC was this, and then there was, and of course those numbers are correct and accurate and all that kind of thing. You can hang your hat on them. And then you've got the, then she drove him to, from the waterfall to 34 Fairview Road. Here's the data that says this and that and this and that. She definitely hit him. We've got Trooper Paul's accident reconstruction testimony, and that shows that there's causation. It's even if it's, to me, it is not convincing. However, it's still like something that he should be able to get through in an hour or less. Also, has 01 Bev talked to the juror and then the juror left the room again. Sidebar is over. Judge left the room. Okay. Interesting. Thank you for this. I think you're reading tweets, I guess. All right. Delford Hassner, thanks so much for the super chat. If you see any red in the taillight at all in the tow truck video, then the taillight pieces had to be planted at 34 Fairview. Oh, here's what it says on the screen. Insider, juror was brought back. Judge spoke with her juror, said all right, and walked back out. Note, this is one of the 4 women. Oh, what? Hang on. We're going back. This is one of the 4 women who were questioned before the last juror was dismissed. Interesting. That is interesting. Maybe it's something, maybe it's nothing. Oh, some people are saying apparently juror 3 was dismissed. Okay. Well, there were 15. They need 12. So, even if there is a juror who is lost from this panel at this point. Oh, has 01 juror 4 has been dismissed. Okay. Interesting. I would love to know like what happened, but I don't know that we'll ever know. Breaking, juror was dismissed per court clerk. Okay. So, yep. Hey, you guys are getting the information to us before court TV. That's great. Caitlin, Legalbytes, why were closing arguments limited to 1 hour? Oh, so yeah, we basically got both of these questions all at once. Spunky Nuggets question: if Karen is acquitted, do you think the family is going to bring a civil suit against Karen or anyone else? Do you think she could be held responsible under the civil standard? Typically, when there is a criminal case, there usually is a civil case that follows. In this particular case, I don't know, because I think that it's so bad for the prosecution's side. It's so bad for the side trying to hold Karen Read responsible for whatever happened, that I don't know that a civil case even would necessarily be successful, because I don't think that you can get there with causation. If she's convicted, then yes, in spades, because the burden of proof in a criminal case is up here. You've got to get over this hurdle. But the burden of proof in a civil case is down here. It's a lower burden of proof. So if you can get over this hurdle, you can definitely get over this lower hurdle, right? So that's why if there is a conviction, for sure there's going to be a civil case, and for sure they're going to win. That's because this is beyond reasonable doubt for the criminal case, and this is by preponderance of the evidence in a civil case, meaning more likely than not, meaning more than 50% sure that she did it. So you have to just kind of like, you don't have to have no reasonable doubts in order to get there. You have to say, it's more likely than not that she did it. But even then, I don't know that we get there because of the causation element here with Trooper Paul's accident reconstruction analysis, and other, they would have to have their own separate accident reconstruction analysis. And, that would have to be like their own expense and everything. They can't just rely on this particular case and say under a civil standard, we still win. So, all right, let me get these other questions in here. We got a lot of questions today, which is great because we're filling in this time. Normally we can just skip through all of these recesses and stuff, but here we are a little bit delayed. Hopefully we can still get closing arguments today. Jonathan Willard question: thoughts on the public defender in the Idaho University murders, mailing out a questionnaire to 400 people that live in the small town the case is being tried. That one, oh gosh, I know. I totally did a video on that one, but it was like partway through. I have to be honest with you. I've kind of forgotten that one. I was paying attention to the issue. I was watching those hearings on that one. And at first I remember thinking, this does seem like you could be tainting the jury pool. But then after the second hearing, I remember I had some modified thoughts on it, and I can't remember exactly where it went with it though. So I'm so sorry. I don't have anything clearer to say at this time, but I'm sure, when the Idaho murders case gets a little closer, or I might just start following it separately also. It's one of those cases that is so deep also that it's hard to just jump into midstream. So it might be one of those that I am able to get caught up on at some point and get up to speed enough to be able to start really putting out regular content on it. Or it might be one of those that I jump in right before trial and then go from there. Also, if it is supposedly it's supposed to be next summer, if it is in fact next summer, that might complicate things for me too, because we might be moving to another country. So military spouse life is fun. It's genuinely great. It's a good life, but that, and it's exciting when you can move to a new place, but you don't want it to line up with high profile trials. But I've heard from people that have been following it more closely that the likelihood of that happening over the summer is probably pretty slim. It's more likely going to be later on, the following year. So we'll see. Evil Bunny 7603, thanks for the super chat. Thank you for all of your work and educational content in this trial. I've been glued to your lives. You are appreciated. Thank you so much. I really appreciate that. Really, really appreciate that. Nick Andrew, is 3 jurors being dismissed rare? I don't know. I mean, it's been pretty common to see 2 jurors dismissed. 3 isn't that crazy either. And with such a long trial, I mean, the likelihood that something happens that a juror has to be dismissed is a bit higher. If it was 3 jurors dismissed in a trial where it's 3 days long, yes, that would be alarming. But here we're talking about 2 months long. There's plenty of things that can happen. All right, is anything happening here? Well, we will continue.
All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court in the County of Norfolk, Draw near,
Body
give your
center.
attendance, and
Beverly
show the
Cannoli.
God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. So I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard that. Okay?
So butt out.
I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And we've all seen how hard the lawyers have worked for this long period of time. We've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. In Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
That's interesting. That's so wild. I'm so used to the opposite. Okay, so before he starts, sorry about the courtroom volume. I can't boost it. I've already boosted. I pre-boost the stream at this point. But for this, she just wasn't talking into the mic, so that's why it was so quiet. But Alan Jackson's going to get up there, and he's going to be much louder.
Thank you, Your Honor. Look the other way.
Oh. Okay. Here we go.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass.
Magic hairs.
Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way.
It's like poetry.
That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want, but it's the greatest responsibility we have as citizens here in America, lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening,
Ooh.
how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left.
Oh.
They'll
Heyo.
magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage, hide personal relationships, make this case cut and dry, and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy.
Oof.
And pin it on the girl.
Oof.
It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks.
Hey,
Drag her through
I've
the
been saying
mud
that.
and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind,
Yikes.
too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. you'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They had been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight?
Awesome.
How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jen McCabe admitted, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me,
Butt dials.
they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe?
Pretty quick.
But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn, period. at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert.
This guy right
Whenever
over
you're
here.
Thinking about this,
You
the
can see my
basement
cursor.
at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body.
Wow.
Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times.
Wow.
It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, She backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. We can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barrows walked into this courtroom. He's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right?
There you go.
The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight, the taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces, and no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight, while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward.
I wish he
And
had
it was
done
cleverly inverted at that.
the Top Gun move.
timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it, which means that was done intentionally. That was not a mistake.
Yep.
And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they've moved up from that.
Ha!
They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47, ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37, and see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence. And now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview. John got out of the car. She reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that.
That's important.
And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner, who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. 2 of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called.
Get him.
They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
Five minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
All right. Thank you very much, Mr. Jackson.
Nice.
All right,
Work.
Mr. Lally.
Thank you, Your Honor.
Let's see how this goes. We're going to get questions after everything.
I hit him. I hit him. I hit him.
There
I
it
hit
is.
him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, "I hit him." You heard testimony from Officer Saraf, statements that he attributed to the defendant as saying that morning, "This is all my fault. This is all my fault. I did this." This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29th, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. And I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a three-card money trick. The facts and the evidence in this case are your card. They're the Queen of Hearts. And so what I want you to, or what the defense wants you to do, is not look at that card. Look at anything else. Look at movement. Look at this person. Look at that person. Look at text messages. Look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the three indictments before this court. The evidence and the facts of this case are for you, the jury, to decide, using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here.
Sure, Jan.
As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional, there's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story through his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering. Stop calling." The defendant then texts John, "Then stop starting with me." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul, asking him to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point in which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime, and a straw. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. The drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, about an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Kolakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Mme. McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe. Speaks with him regarding directions, sort of going over which way to come in Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV from each of those respective videos. 12/19/32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a three-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky D'Antonio pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32, 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Miss Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that three-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, for 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the three-point turn when the vehicle is in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:50, John, see you later. 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert."
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there. She had struck him there. She had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., She calls Mr. O'Keefe and leaves this voicemail.
John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself.
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or anybody to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe and where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a cloud. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911, something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, and calling your parents, and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing the steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken taillight at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before, and she had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's.
There's literally no evidence to suggest that.
5:20.
Nothing in the digital
I'm
forensics.
sorry, 5:33 is when the defendant, Ms. McCabe, and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, and no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with a vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, The defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. But the defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search for evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department south. To circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. You heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Ms. Reed, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. The defendant shows up at the house, abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drives that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages in the phone call on January 28th. You've heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. The defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dighton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. You heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece, Kaylee, John tried to diffuse, he tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have the testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with the father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots. Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, at which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. The variety of stories that the defendant tells on the morning of January 29th. There are text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call her Julie Albert. Because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, this is a phone call that both Ms. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband, Matthew McCabe, reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview. So she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead. And then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he had some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Laura Sullivan from January 29th, in which the defendant indicates to Laura Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. McCabe, and Ms. Roberts around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18, 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitman as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of them. Also from Trooper Garino as well. These searches were unequivocally done at 6:23, 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whiffen, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those first responders indicate is that the defendant repeatedly stated, is he dead? Is he dead? Not, is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18, 5:35. The repeated questioning, firefighter Whitley, firefighter Woodbury, asking Ms. McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for when she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Ms. McCabe and Ms. Roberts. I say them together because as far as these two women were concerned, they did not know each other really at all. The only time, as they both testified to, that they had ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reeboks outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Albert said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, going down Fairview of coming off of Chapman, that you first go down a big steep hill. It flattens out for a little bit, and then you go down a second, 2 hills going down on Chapman, matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. And she's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before, and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions, and she indicates that she uses a house that Mr. O'Keefe will be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, from a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Ms. Roberts and Ms. McCabe in Ms. Roberts' car. She's still talking about it at that time. It's that much on her mind. Ms. McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Albert Jr., as did Julie Nagel, as did Ryan Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece, Kaylee, at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, did I hit him? Could I hit him? Then they start discussing, or the defendant brings up her cracked tail. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock in the morning. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicate And you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. And so what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they come out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows he's
Such a
not
stretch.
coming home because she hit him with her SUV and she left.
That
him
is such
in
a
the snow.
stretch.
Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. Defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant from the back seat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe was laying on the front lawn.
Feeling like Judge Cannone right here with my
We have
size.
testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on scoop stretcher and then bring him over to the ambulance while they're conducting resuscitative efforts trying to save Mr. O'Keefe's life. But Ms. Roberts indicated that she observed underneath him, only the phone, but the phone on the grass. On the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now,
Hoss
recall,
long.
around
Thank you very
12
much.
o'clock or so is when it starts to snow and it starts to stick a little bit. And you heard all that testimony. And I know it was a lot of testimony about snow, and a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, is still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there.
Hoss long.
Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted and Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like.
And how did it not
See,
melt off
however,
with the
is
water?
damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th at about 5:30 p.m. until February 1st when they conduct the search warrant, the hair isn't still frozen as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted. As you can see.
How did it not
from last
fall with the melted
round.
snow?
The weather, also important, I would submit, weather was a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt.
He just wants to be a meteorologist, you guys. That's his next
You
career.
heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe, that initially on scene, there was one eye that was swollen, not the other. So that's indication of the swelling that Dr. Scortibella was testifying to, with no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony.
Sorry.
You have the testimony
reconstruction
from Ms. McCabe and
testimony.
Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Saraf's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Saraf. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments and incessant phone calls and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas. The men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfront. Same testimony that you heard from Ms. Kolakithis, observing the defendant going over to her vehicle, getting the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger's seat. She said they were left the waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house from the testimony and the data points that you have from Trooper Guarini. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Nicole Albert, Brian Higgins, all indicated in their testimony, and the defendant knew, based on our questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the waterfall. The weather was a weapon.
The weather was a weapon?
You have the testimony about the car, the defendant's car being
He truly is Elsa. Sorry, I didn't want to pause it, but that one got me.
there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse, a three-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking a left onto Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. There's reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Ryan Nagel, Ricky D'Antonio, and Heather Maxson drive away from that. We heard the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have the testimony recalled, and you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Warning.
Yes,
Yes.
Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in earlier in the day, getting a couple slices of pizza. What are you doing later on? Contained within those texts. You have the testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level, 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Flamati to Dr. Rice. You heard the testimony regarding the defendant's blood alcohol concentration with Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. You heard it, Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. And you have the witness testimony in the surveillance video in regard to the forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck him, and he did a pirouette and then flew 30 feet in the air.
Trooper Paul said that.
12 inches of abrasions. That
Your
the
accident
doctors were, the
reconstructionist said
biomechanical
that.
people were talking about yesterday. 12 inches and then 6 inches for the tail end is easily solved by this. And the dimples on his arm are, that I would submit, are consistent with the dimples on the tail light cover piece, are right around this area of the elbow.
That? I'm sorry, what? He's saying the dimples on the taillight? That's the first time that anyone has made that connection in this entire trial. And that just sounds completely outlandish. Completely outlandish. Like, no one has testified to that. They're like, oh, okay, there were dimples on this thing. Okay, fine. But like, what? What? Okay, sorry. I'm trying not to pause here.
You have testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight housing, on the house. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have the testimony from Ms. Hartman and Trooper Paul as regard to the damage that they observed, the dent, the scratches, the 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, sir. All consistent with pieces of taillight that are found within his clothing. Ms. Gilman, if I could. 605, this is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago,
He's
practicing
gone over an hour.
Braintree, what is now Quincy. Eventually became a far smarter man than myself. Eventually became President of the United States. His name was John F. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence.
Like how you just made up two
What the
pieces of
constellation
evidence?
The facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing his death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence.
1 sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right. Thank you. Jurors, I have my instructions on the law. I'm going to do.
Before we do those instructions, we have to do one thing.
It's been 84 years.
Yeah. Yeah, that was a a very long closing argument. Let me get this one really quick, just because these details will disappear here. Just because, thanks so much for gifting 10 Legalbytes memberships. So kind and generous of you once again. So let's see here. This was Michael Peterson, Jessica Sand, Ashley, Paula Shamek. Who else did I miss here? Kristen O. Who else? Insert funny name, Geeky Nerd Demon. And Denise Marquez and Fade to Gray, No True Dino Man, and KC. You have all been gifted memberships, so welcome back to Bike Club. So happy to have you guys here. There are other super chats and other things like that, but those details will float away. And I like to tell people when they have been gifted membership and by whom, just because sometimes people miss it. Okay, let's get to what is next here.
I give you my guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break?
Yes.
We can take a short break. Okay, we'll come back in 5
Yes.
minutes.
People need to wake up.
You are muted.
Oh my goodness. Well, there were two bits of testimony that were made up in the prosecution's closing argument. That was fun. Like the fact that he says based off of literally nothing. Or here we go, like this. Somehow the digital forensics didn't show it. The cell phone towers pinging, the like literally nothing showed that Karen Reed went to 34 Fairview Road between going to the waterfall and going to Gemma Cabe's house on the morning of the 29th. But Lally's like, trust me, bro, she actually did go there. Like, I'm sorry, what? And then also the dimples on the arm. Literally no one. There was a question. There was a question in the chat. I may have saved it. Someone was asking, what does that mean? The dimples on the taillight piece. So there was a one piece of plastic taillight, the clear plastic taillight that looked like it had little bumps on it, and that's just to give it some certain features with the lights, to make it look different. But on one side, they're like little bumps, and those would be on the inside of the taillight. So he's saying that when John O'Keefe hit the taillight with his arm, that plastic piece with the dimples on it, those little bumps, caused all of those scratches, all of those scratches, all of those abrasions on his arm. That's bananas. That's completely bananas. Literally no one said that. None of the medical examiners, none of the accident reconstructionists, like no one said that. So like, where is he getting that from? That's just like nuts. I was wondering why he kept pointing out the dimples in the taillight pieces during the trial. Cause I was like, what, like, what's the point in that? I guess now we know. That's just nuts. Completely nuts. Okay. All right. Let's get super chats and questions here while they do their recess. And we're live, by the way. So we're not there. Oh, and also, by the way, we've got over 2,400 people watching. Thank you so much for joining us for this coverage. If you haven't done so already, please do hit the like button. It really does help us with the YouTube algorithm gods and pushing this out so that more people can come and join us and see our coverage here. Of course, it's the last day of this trial, but we've got many more trials to cover and many more topics to cover on this channel. So pushing this out does a great thing. And also more people might want to come in and watch the case. I've had trials before where people come in and watch from the beginning long after the trial is over. So, if you guys like the video, it definitely helps to push it out to more people so that they know about it. And if you are really enjoying it, if you're new here, you haven't done so already, subscribing to the channel is a huge, huge help. We are so close to 250,000 subscribers. We are, we're just under 248,000 right now, I think. So we're so close. We're within striking distance. So that, and if you are absolutely loving it and you want to know how to support the channel, because, this does take a lot of resources to put on full trial coverage, especially with the live streams and the recaps and everything. If you would like to support, if you're in a position to do so, joining Bike Club is the best way to do it, either through YouTube memberships or supporting on Patreon. We've got perks, like we've got a weekly members only live stream where you can come in and chat about anything at all. You get you get early access to all of our regular uploads that are non-trial recaps. So, great stuff, great perks. And you're also supporting a channel, supporting a small business. So, but otherwise, liking the video is the best way to do it, if nothing else. Okay. Let me save this right here. I hope that I have not missed any other questions here. Alex025, will anything happen to the police after trial? I don't know. Oh, we already got that question, actually. Let's see. Moving on down. Megan Rose, the lady next to Colin, is giving Uncanny Valley. Oh, I must have missed that. Delford Hessner, thanks for the super chat. If you can see any red taillight at all in the tow truck video, then the taillight pieces had to be planted at 34 Fairview Road. I agree. How else do you explain how they got to 34 Fairview? La Heathers, can we talk about Albert's sitting behind the JOK family? They were there. They were there. I saw Brian Albert, at least. He was mostly stone-faced, I think. Evil Bunny 7603, thank you for all of your work and educational content in this trial. I've been glued to your lives. You're appreciated. Thank you so much. I really appreciate that. Brian Stark, thanks for the super chat. Poll on jury deliberation time. All right, we'll give it a little bit of time more for this current poll, and then we'll close it out and we will move on to that poll for sure. But yeah, that's a good one to ask. TJM, thanks for the super chat. If not guilty, then I vote Alita has to do the Macarena on the stream. Really? I don't know. I might get copyright claimed if I put the Macarena music on. TJM, thanks for this super chat. Maybe the dog stepped on a bee. Maybe that's what happened. She was triggered. Haas to break the wall, says Sue B. Thanks for the super chat there as well. And Brian Stark, thanks for the super chat. Only 18 minutes left. Oh, thanks for that countdown there. Megan Rose, thanks for this super chat. Is the jury allowed to go back and watch evidence, videos, and pictures during deliberations? Yes, they can request those. If they have been admitted into evidence, they can request those. They can watch those. It's one of the reasons why Alan Jackson at the beginning directed them to a particular timestamp. Was he was inviting them to go back and look at the Waterfall Bar and Grill footage. Ray Lawston, it is like witnessing a witch trial. Where is the evidence you speak of, Lally? Did you check to see if Karen can float? No, but he did check to see that somebody had spoken with the crime scene at least. Honest Mike, thanks for the super chat. She found him. He is using the well-known case law of finders versus keepers. Exactly, right? Carmen Brown, no, he said it wouldn't cause that type of damage after hitting J.O.'s vehicle. Yeah. Adrenia Gates, Legalbytes. So the CW within 10 minutes of closing says she had 9 drinks and was impaired, then drives 24 miles per hour in reverse in a straight line in the snow and hits OJO. Don't be suspicious. Yeah.
Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
Love it. Just because, thanks for this super chat. There's no evidence of anything. Good pause, Lolly. Megan Rose, if it was snowing harder enough to cover John, it was snowing hard enough to cover drag marks and footprints. Yeah, you'd think so, right? You would think so. Alex025, who dropped the better diss track, Lally or Jackson? Honestly, I want to see if we can play the beginning of Jackson's closing argument and put it over a rap beat and see if it fits, because he had a good enough like steady rhythm to it that had like, I don't know, it had like a very poetic kind of rhythm that I wonder if it would fit, if we could find some kind of a beat track that would actually fit. Megan Rose, I bet Lally thinks he ate. Maybe. Wingy158, thanks for the super chat. If I was on the jury, I would purposely take an hour nap during Lally's closing. What would the judge do? Yell at me? Yes. Well, maybe not yell at you. The judge would maybe have a quick recess or something, things like that. Judges will do that kind of thing if a juror starts sleeping. Melanie R's, thanks for the super chat. The bumps caused the scratches, but the clothes had holes, puncture holes. He knew he was going this way when he talked about the texture of taillight. Yeah. Paula Hoslong to be found not guilty. I don't know. We've got to find out. Mountain Princess 207, thanks for this super chat. Haas, many likes to 1,000. Let's see. Let me refresh here. We are at 916. We're close. We're very close. We are very close. If we can get to 1,000, that would be amazing, you guys. Okay, let me get some more questions here, and then I'm going to start going through some regular questions as well. Okay. Moving on back up to the top of the line here. Jonathan Willig, thoughts on the public defender in the Idaho? Oh, wait, I already got this one. Okay. Sorry about that. Kate, question, can this case have larger ramifications on state case law? So not in terms of like, does it create precedent for other cases? Because this is at the state court level. So when we're talking about cases that create precedent, you have to first look at the hierarchy of cases. You've got the superior court level, and there are different names for this from state to state, but I'm using the language that I'm used to primarily from California. So like superior court level, that's like the trial court. Then there's the appellate court level, and then you've got the state Supreme Court. That's state courts. Federal, you've got something similar. You've got district courts, you've got appellate court, and then you've got the United States Supreme Court. So the United States Supreme Court is also like just up here, and then the state Supreme Court is down here. So, that's the ultimate court right there, of course, as people are generally familiar with, is the United States Supreme Court. So any kind of those lower level courts, whether it's the federal court, that's the district court, or the trial court in state court, those are like baseline level cases. They don't create any kind of precedent. They can create law that other courts can look at and say, oh, I like that reasoning, and then adopt that reasoning. However, no court is required to follow precedent followed by any like lowest court. When you get up to the next level, appellate level, it depends on which superior courts are within a particular appellate court district. So if it's like one of your appellate courts says you have to do this is how we look at the law, you have to follow it. It's mandatory to follow it. But if there's an appellate court, but it's like over here in some other state or some other district that isn't binding on you, that's called binding, is when it's one that you have to follow. Then it's persuasive. It means you can use their logic to persuade the court and basically say, this is a great idea. This is what they're following. And so we should follow this too. So that's like when you start to get into precedent is the appellate court level. And then like Supreme Court, state Supreme Court, everyone in that state has to follow that. United States Supreme Court, everybody everywhere has to follow that. So that's kind of how precedent works. So again, the lower level trial court level, like that's where we're at right now. No precedent is set by any of these cases. So, all right, and we hit 1,000 likes. That is amazing. Thank you so much, you guys. Yay! 1,000. So great. Thank you so much, you guys, for helping to support the stream and the channel. This is a wonderful, wonderful thing you guys are doing here. Okay. And are we still...
Ms. Reed committed the crimes charge.
Sorry, guys. I didn't realize that it stopped playing. Okay, let's go back here. Now we're going to get into jury instructions. Okay, so I will pause questions. I'll get back to these and super chats when we come back from the jury instructions. Okay, so yeah, we're going to change the poll now. So 3,200 votes, 95% said not guilty, 4% said
All right,
guilty.
jurors. Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses or provide any evidence at all because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They are simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But Your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth.
So that's if you guys were watching through the jury instructions yesterday, the like argument, I guess you could say, through that was the Bowden instruction that they were arguing, that she initially said that she probably wasn't gonna include. Defense argued for it, and it looks like it got included.
All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were in fact John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight, that is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me
Another if
talk
any.
about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? Inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions. Now I'm going to turn to the elements of the charges against Ms. Reed.
All right. Elements of
The
the charges.
Commonwealth has alleged that on January 29th, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point.
Uh-oh.
Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and could control the...
Oops. Dang it. Sorry, brief interruption.
Vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions.
Last leg, guys.
In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The
Fight to the
jurors
death.
not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, in that sense, is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong, but no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to seek counsel before we reduce your number to 12.
All right. Okay. Fast forwarding through this, probably until almost live. Okay. Almost. Actually.
You're sitting in seat number.
Okay.
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate?
Oh, 79 is an alternate.
And the juror sitting in seat number 2, juror 14.
All right. So,
Those
ladies
are the
and
two
gentlemen,
alternates.
we need to swear in the court officers. They're going to be in charge of you during your deliberations. I
Said the court
suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they're discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right. So, jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me.
All right. Jury is going off to deliberate.
You may be seated.
All right. So, counsel, I'll give you a few minutes to work with Mr. McDermott on the verdict slip, and then I'll come back out.
Thank you, Your Honor.
Okay.
All rise for the court, please.
Okay. So let's get some questions here, shall we? The jury is officially deliberating now. This is live. So we got up to about two minutes when she saw, like 2 minutes behind when she swore in the officers and sent the jury out. Okay. Questions as we go along. We've got a lot of them to go through. Okay. Alrighty, let me see. There are first some super chats here, and then we'll get some other normal questions too. Sorry, just scrolling down here. Okay, we went through this one and this one. Okay, sorry guys for the dead air, but I'm just trying to find the right one where we left off. Okay, Mr. W, thanks so much for the super chat. What was his strongest moment in closing, in your opinion? What was the weakest? So I think you're talking about Lally's. I think the strongest moment was the beginning, the very beginning, when he said, I hit him, I hit him, I hit him, I hit him. And, you know, emphasized that. I think it slowly kind of just trailed off from there. The weakest points were two of them. Well, there's three aspects that I think were particularly weak. Two of those were the parts where no one testified to something and he's just sort of filling in a gap. Like, you know, like I already talked about how he said that Karen Reed went after 5:18 a.m. She went from the Waterfall Bar and Grill to 34 Fairview Road to Jem McCabe's house when there's literally no evidence to suggest that. There's none of the pinging cell towers or any GPS or anything has brought in to suggest that at all. So he's literally pulling that from his ass or pulling that from the air, if you prefer to say it in a classier way. And that was a very weak point. The other weak point was a part that was no one talked about, was the fact that he said somehow the dimples caused the abrasions on the arm. None of the medical examiners, none of the accident reconstructionists, no one said that that was a thing. The only one who said that the taillight caused those abrasions in some form was Trooper Joseph Paul. But he didn't even say those dimples caused, you know, like those dimples caused the abrasions. It was like, the way that he said it made it sound like the shards of plastic caused those, almost like incisions rather than abrasions. So weird, two weird points. And then there's the fact that he didn't talk about how Karen Reed's car caused any of the other injuries aside from the dimples, right? Unless I missed it, right? Because admittedly, he did this, I don't want to call it an alley-oop, it's more like a lally-oop, where he circled back over the testimony or the timeline again. You know, at a certain point earlier on, when he's got a timeline has a visual and all that, I was like, okay, this is good. This is helpful to the jury, that you're going through these timestamps, you're connecting up these different call times and text times and things like that. Okay, that's good. That's helpful. And then he stopped using the timeline and then like went back over a bunch of the stuff that would have happened on that timeline, almost as if it was like the timeline was the first half. And then the second half was like all the word vomit spaghetti on the wall. So like, yeah. So like this lally-oop of argument was him just kind of going over and over again. And the second time around was a lot harder to follow along with than the first time around, which was a bit more organized, I want to say. So neither time did he talk about any specifics about the injuries to his head and which was the cause of death. Like everyone agreed that he died by blunt force trauma to the back of the head. Like that was the blow that killed him. Whether or not he had any impact on his face previous to that is, you know, I guess up for discussion between the different medical experts. But like everyone agrees the back of the head. It's like, why didn't he at least say that? And then talk about how the car caused that? There was nothing in there. So it was very, very weak on a very crucial point on causation. So that was important. And I think, once again, if I missed it and somebody else caught it, please tell me, because that is an important thing. Like, tag me in a chat here and tell me, that he said it, because that you saw him say it, because I didn't see it. I want to catch this really quick because it doesn't show up. It just says super sticker on these. Joshua, thanks for the super sticker. There's a little dog that says my hero. That's very cute. Thank you. Thank you. So, yeah, that was a little, it had more weaknesses than strengths, in my opinion. Ray Lawston, thanks for the super chat. Do the Alberts and McCabe's think their being present makes them look good? Seriously. Well, they are sitting with the O'Keefe family. So, and it seems like that's where the O'Keefe family has invited people to sit with them. So folks have been asking throughout this trial, do we know what the O'Keefe family thinks? Do we know what the O'Keefe family, feels about Karen Read and whether or not she's guilty? Other than actually what I've said in the past, I forgot about the fact that John O'Keefe's mom had said to Carrie Roberts, make sure that you guys take down a timeline, make sure you guys write down everything so you can remember, essentially suggesting that she thought that Karen Read was guilty, even though she wasn't there and, wouldn't have any reason to know other than through hearsay. But this is another indication that maybe the whole family thinks that Karen Read is guilty here, because it seems that they have invited the Alberts and the McCabe's to sit with them. So that is something. Doctor Who 8675309. Thanks for the super chat. Thank you for wonderful coverage of this trial. You kicked butt and provided a wonderful learning experience. I do have to ask, if weather's a weapon, are meteorologists accessories to murder? They might be, if it's bad weather, right? If it's weather that causes harm, they might be. Also, thank you for the kind words. Very, very kind of you. Gunnar Dennis, thanks for the super chat. Will the jury be sequestered? Nope. Not as far as I understand. No one has talked about sequestration. It takes a lot to sequester a jury. And in this case, I don't think that is on the cards here, at least not anytime soon. Okay. Kate, can this case have larger ramifications on state case law? Oh, I already answered that. We talked about, precedents and all that kind of stuff before. Solo Cup evidence, Legalbytes, you need to send the court report in I survived 2000 what if any's. That would be amazing. If I could find out the contact information for the court reporter, somewhere to send mail. I would love to send some kind of merch for the 2000 what if any's to her, because more than anyone else, she has survived it. XMO question, how do sides find their experts? And can they refuse to take part? Do you know if they still get paid if they volunteer? So the way that you find experts is you ask around to either you use your own Rolodex, or you sort of ask around in your network. Have you ever worked with an expert witness on this kind of an issue? Do you know of anyone? That kind of thing. And then you start having phone calls with potential experts. You ask them for their CV, you ask them for their background and all that kind of stuff. You give them the basics of the case. And then you ask them, like, would you be willing to look into this to perhaps, give a report on, what your thoughts would be. So that's kind of how that happens. It starts with a conversation, and then you get more and more in depth if you both decide that you want to continue, working together on that question. Then either side can decide, no, I don't, either as the attorney, you can say, I don't want to work with this expert. They're not the right person for this case or for me or for what have you. And the expert can also tell the attorney, like, based on what you're telling me, I don't think that I can provide you the expert, testimony that you're looking for. So both sides can say, and, usually I would, in my experience, for drafting up like a full report, there usually some kind of a fee, because that takes time, that takes effort. that kind of stuff. So by that point, you've already got engagement, most likely, like a full report. But if it's just for the basic conversation, like there's generally no payment in my experience. EB, Legalbytes, if the alternates were already dismissed and one juror were to leave, would that be a mistrial? Not necessarily. Sometimes you can end up with a jury that ends up being 11. Like I've heard of that because somebody, like during deliberations, something happened to them. But oftentimes it does. I mean, it depends on the circumstances of like what happened with that one juror. Life on makeup. I saw the expression on Paul Key's face change for the first time yesterday from daggers at KR to confusion and shock. What are your thoughts? I was paying less attention to his expression. But yeah, I mean, I guess it did seem a little bit less severe than before. So, I mean, yeah, I guess I'd agree with that. Mark Smith, I want whatever you're drinking. I am drinking water and LaCroix, fizzy water. Because as you guys, many of you, probably most of you know, I'm growing a small human, so there's nothing alcoholic in this body, not for many months at this point. So yeah, that's basically that's what I'm drinking. Water and fizzy water and more water. No lean burn. Legalbytes question, please. What was the significance of Jen's phone calls to John O'Keefe's phone? Didn't understand that. Thank you so much. It depends on the perspective. So from the prosecution side of things, they're saying that the prosecution side is saying that she was trying to call him to see if he was going to come into the house. That's what that was all about. Defense side, however, is saying that she was trying to help and find his phone because they realized that his phone was not on him at one point after some sort of an altercation happened, and that there was no way for him to find his phone because maybe he was unconscious. That's what the defense is saying about that. So that's the distinction between the two. LK Ryden, Legalbytes. But one reason I think the jury might be super fast is that it's not just about guilty or innocent. They may say the evidence is too messed up to call it either way. Yeah, but they may also say that either way, they may also say that they still want to go through everything first to confirm that. Stella by the Sea, thanks so much for the super chat. If I were a juror, I would be intimidated by BA's presence. He is scary big and can find out where I live. Jury tampering, IMO. Maybe. I mean, I can see that, but if he hasn't said anything to the jurors, if he hasn't had any kind of contact, they're not supposed to, their personal information is never supposed to get out. The two parties can learn their names and some of their personal information, like their full name. For example, Karen Reed has probably heard all their full names, but phone numbers, contact information, things like that. But also the witnesses weren't there for jury selection. So they wouldn't have been there for that. They would have had to get that from, say, the prosecution or someone else on someone connected to the prosecution's legal team. Natalina Rose, Legalbytes, I think you have more faith in Lally than I do. Question, do you think Lally truly thinks she's guilty? I mean, based on the beginning of that closing argument, it sounded like he had more conviction than usual. Like he definitely had more volume at the beginning, more passion than we've ever seen so far. But it did kind of dissipate after a few minutes from there. And then he kind of went to his normal rhythm of just like speaking. Baz 80's question, given the witnesses and evidence, could Lally have done a better job to be convincing of her guilt? Or was the evidence just not there? I think he could have if he had cut out some of the witnesses, for example, and then also narrowed the scope of what it is that they were trying to prove. I think that if they hadn't gone for second-degree murder, They could have gone for something a little bit less ambitious and then perhaps prove that. Now they do have those lesser includeds. I thought that they said that they weren't going to be pursuing lesser includeds yesterday, but that turned out to be a little bit different. We did get some lesser includeds as to the manslaughter DUI charge. So Desiree Bula, question, why are the defense and CW able to argue in closing? What should the jury take away from closing? In contrast to opening, which the jury should just get an idea of what will be presented. So the reason for that is because at opening statements, there is no evidence that is that has been admitted. So they, either way, whether at the beginning or at the end, they only arguments that can happen. The only arguments that can happen are those that are based off of the evidence that's been admitted. But at the very beginning, you haven't gotten to that part to admit the evidence yet. So that's why you can't argue at the very beginning, but you can at the end because everything's been admitted, and you can use the stuff that has been admitted in some form or another to argue to the jury. I hope that makes sense. L. Mahaney, question, do you think that draining the coffers was a strategy by the prosecution in calling so many witnesses and going so slow? I sure hope not. That really shouldn't be something that is some sort of a trial strategy for one side, because it's a waste of money and resources for everyone. Nico Kiski, Legalbytes, will you be keeping up with the follow-up of this trial? I'd love to know if anything new comes out from the FBI investigation, for example. I think so. I think this has been very interesting. If there is more that comes out from the FBI investigation and more, if there are any criminal charges or anything like that, that would be very, very interesting. Sue B, question, does judge or jury do the sentencing? Well, it depends, actually. It depends on jurisdiction, and it depends on whether the trial is bifurcated. So, for example, I've talked a lot about the love triangle bicyclist trial in Austin, Texas. That one was not a bifurcated trial, and the jury actually did both. They determined guilt or non-guilt, and then they decided the sentencing, and they determined that she was guilty, and then they put her in jail for 90 years. So that was that. Most cases that I've seen, the judge will do sentencing, and that's usually by request from the defendant. The Rubber Duck 77, Legalbytes, I didn't know you watched the charges feed. I watched it on Court TV, so that's okay. I didn't know if I was going to, and then it came on as I was still answering questions. So I was like, all right, well, we'll watch this. Aloxar Sidaran, Legalbytes, who do you think should do closing arguments for defense, Jackson or Yannetti? I was all about Jackson doing those closing arguments, because you that's where you bring the fire, is in closing arguments, and Jackson is the one. Not to say that Yannetti isn't capable. I think he's absolutely capable, but Jackson brings the fire, especially like a special kind of fire. Genergy, can she be acquitted of all charges? She absolutely can. 100% she can. Stella by the Sea, how do I donate a membership? That mods actually are going to be best to answer that question. I think if you go to the dollar tab, yes, if you go into the chat, there's a little button that looks like a dollar. There's an option for membership gifting where it says buy memberships for viewers, so you can do that. Also, there's a question here from Buttercup 203. This is a new one, but it's a follow-up to what I just said. What's bifurcated? That means it's separated. So in other words, separated into two proceedings. You've got the trial itself, where you end up with a verdict, and then you have a hearing, and then you have a hearing much later where they determine the sentencing. So that's more typical, is when the sentencing is done at a later date. But the one in Austin, Texas, it was like right away. It was actually, if I may,
right to jail right away.
That was actually literally right to jail right away. Baz 80s, question, if a juror causes a mistrial, does KR have any relief for fees to retry the case? Not that I'm aware of, no. Unless So if a juror deliberately causes a mistrial and there's enough proof of it, then they can absolutely be fined. They can even be imprisoned. There was a case, I did a video on that, like, I don't know how many months ago, but like earlier this year, about a juror who intentionally caused a mistrial was it in Florida? I think it was in Florida. She literally was like walking around to other jurors saying that she was going to intentionally cause a mistrial. And then she did. And then all of this blew up and they had a whole like separate trial for her and everything. And I think she might be in prison at the moment. So yeah. Sheena Ford, can they just dismiss at this point? They could, but at this point, I don't think that the prosecution ever would. Rubber Duck 77, how did you feel about them using the lesser included charge of assault with deadly weapon to argue consciousness of guilt by hiding the murder weapon by taking her car to her parents' house? I think it's dumb. I think it's really, really dumb, because the more likely explanation of her actions is she lost her mind that morning. Her boyfriend was found dead and frozen on a lawn. This was after she was like really stressed out and very angry at him because of some arguments that they had before. And, you know, I can understand why under those circumstances, she wouldn't necessarily want to hang out with his family, because she also is probably still parsing through feelings of being mad at him from their arguments before. That's a very, like, saying goodbye to someone when you've just had a big fight with them is like the worst way to say goodbye to someone. Like that's a lot of emotions to work through at that time, and then probably feeling very guilty whether or not you had anything to do with it. So of course she would want to go to her parents' house, like, obviously, rather than his family, because there's just so much for her to deal with. So I think that argument about hiding the murder weapon, like, she didn't go to another state. I don't even know if she went to another county. If she had gone somewhere and went to some hotel, you know, by herself, or some cheap motel that's off some country road somewhere, I could see that. I could see that argument. But like, she went to her parents' house. That is like the most reasonable explanation is she needed emotional support for herself, and she didn't feel comfortable getting that from his family. So EB, Legalbytes, would there be consequences for a juror if they deliberately cause a mistrial? Yes. Yes, absolutely. Like I said before, they can be fined. They can even be imprisoned. Splits personality question. And it's so funny, actually, by the way, from that last question about the juror, before that video, I made that video, I would have, actually, that was like in January, I think that happened. Anyway, it doesn't matter. Before I came across that story, made a video about it, I never would have thought. I would have been like, you know, this is like, that's so rare. That's never going to happen. Like, that's just never going to happen, et cetera, et cetera. Like, yeah, but then it happened. So also, guys, don't give us fake news in here. Verdict is coming in 30 to 35 minutes. Official statement from Yannetti on Tom CPU. No way. I highly, highly doubt that. So please don't fake us with you know, fake news here. Okay. Because I've got the feed up with the journalists from the courtroom, and they will be tweeting first about it when they hear about it. So, but I appreciate your enthusiasm. Splits personality question. What role does the foreperson play compared to the rest of the jurors? So the Judge Cannone did go over that in the jury instructions, right? She said that the foreperson is first among equals, meaning that they're, it was streamed live on Tom CPU. No way. I will believe that when I see that on Twitter. How's that? I don't see anything so far. Okay. So what role does the foreperson play? Back to this question. So the foreperson is they've got one vote just like everybody else, but they are basically the ones to organize the discussion, to sort of moderate the group essentially and say, like, let's go through the jury instructions. We're going to take this route. We're going to go through here, and here first. This is the path that we're going to take towards making this determination overall. That's what they're going to do. It's interesting that the judge just sort of picked someone as opposed to letting them choose themselves. There can be benefits, there can be costs to letting them choose themselves. Sometimes when somebody, decides to be the foreperson, it's somebody who is a little bit gung-ho on what they think should happen. How they think that everybody really feels or should feel about the verdict. So, they can then use that role to perhaps influence others, but at the same time, like, the downside of having the judge pick someone is if she picks someone who isn't necessarily someone who's good at moderating people or, organizing people, or just sort of being a voice in the room that has any sense of authority, that can be a little bit harder to manage for everyone, right? And it could end up being that there's like some other de facto foreperson that kind of just sort of steps up anyway. Things like that can happen in that kind of scenario. But yeah. Tish, Legalbytes, I didn't watch the jury instruction hearing yesterday. Can you summarize what happened? Basically, they went through the basic language that they were going to go through and kind of were like, are you okay with this language? Are you okay with that language? Most of it was agreed. It was actually very fast. It was a lot faster than the actual jury instructions reading to the jury. But there was a little bit of argument on a few things here and there, but for the most part, like I said, it went pretty smoothly. That's the basic summary. Julia question. I saw a lot of people at the courthouse in support of Karen Reed, which must have some sort of impact on the jury's opinion of the case. Do they do anything to minimize that? Well, they usually have the jury show up through a different door so that they're not identified, so that they can feel like they're going in and not being harassed, things like that. I mean, there should be barriers and whatnot. There is Judge Cannone did set up a rule at the very beginning of this trial saying that the not protesters, but people that are in support or against Karen Reed, anyone who is there using their First Amendment right to protest, they have to stay 200 feet back from the courthouse. That's what the judge determined, just to prevent any sort of disruption to the courthouse, prevent any disruption to the jurors and things like that. So that's my understanding, is that they throughout this entire trial, they've had to stay that far away. And that is a valid restriction on speech, by the way. I know there was a lot of argument in the very beginning about, like, this is, unfair, it's the First Amendment and all that kind of stuff. But that is a time, place, manner restriction, which is like one of the easiest ones for the state to be able to uphold, essentially. So they're able to do that pretty routinely. Jerry Roth question: do we know why or what the FBI is investigating yet? So people who have been following this case much longer than me will definitely know better than me. But I think that they're investigating into the investigation itself, like the police, the prosecution. I think that's what they're investigating into. KJ Height question: did you know she has a Dateline interview and they are going to release the episode after the trial called the Rear Taillight Murder Trial? Interesting. I did not know that. I saw something about some kind of a documentary, but I wasn't sure about what it was. I'm wondering if it's a Dateline documentary. I don't know. Elena, get ready to party clip from Bridesmaids would be a great before closing arguments. That would be awesome. Yes, absolutely. Let me just get these also. Y'all are so great with these questions. Jerry Roth, didn't HDR verdict come in about 3 hours? That was super fast. I was surprised at just how fast that one came in, but that one also was a conviction. So convictions tend to come in faster than acquittals. They do, but they don't necessarily mean an acquittal when it's super fast. In this case, I was either way. I wouldn't expect it to be immediate. I wouldn't expect it by the end of the day for me personally, but end of tomorrow, perhaps. Yeah, maybe. But yeah, I don't know. I don't know beyond that. Chad, question. Are lawyers allowed to charge lawyer fees during jury deliberations since they aren't necessarily performing services during that time? If they are, on the clock and they're working, like, for example, there may be times when there's a question from the jury that needs to be answered. Both legal teams will be called back into the courtroom for the reading of the question. And then the judge will put on the record, like, what she's going to do about whatever the question was. So anytime that they are requested to be present there in the courtroom for something during these deliberations, or they're otherwise working on the case, they're doing, press conferences or anything like that, that's all billable time by the attorneys as well. So, yeah, there are some things that they may be doing regardless, or maybe even organizing things for potential appeal, or, there's other things that they may be doing behind the scenes that's organizational for some possibilities here. So, yeah, anytime that is spent on the case, they are allowed to charge. Still by the sea question, why would McAlbers be allowed to sit in court? If I were a juror, I wouldn't want any of them to know who I was. It seems like they were there at the request of the family. Hussar 1683, Legalbytes, not a question, but I strongly recommend John Grisham books, especially Runaway Jury and Time to Kill for the lawyers and court drama from an actual lawyer, available in audiobooks too. Yes, John Grisham. I read one of his books in law school. I can't remember exactly which one, but he was really good. It was good. I enjoyed it. Janet G, Legalbytes, do you ever go back after closing arguments and rewatch opening statements? It would be interesting to compare. Some folks have said that might be a good idea, to go through and rewatch the opening statements and see where the goalposts have been maybe shifted. Ice Cool 2020, Legalbytes, sorry if you answered yesterday, but what would happen in a hung jury, retrial, or dismissed with prejudice? So in order to get to a hung jury first, they've got to be deliberating for a while. And there has to be essentially not just that they've been deliberating for a while, but that the jury hasn't made any kind of movement on those deliberations. If they are taking a long time, but the judge asks them, like, how's it going? And they're like, we're making progress, we're going through all of this stuff, then she's going to continue to give them time until they like reach basically an impasse. So if they get to that point where they are at an impasse, then that is the judge will declare a hung jury. If that happens, that is a mistrial, which means there's no official determination one way or another. So there's no dismissal with or without prejudice. Basically, what that means is the state is able to, or the Commonwealth in this case, they are able to bring the charges again and have a new trial. That has happened many times before for other cases. But they can also decide not to bring the trial again, because they may look at how things went down the first time around and say, I don't know that we can win this. Maybe it's not worth the public resources. Maybe it's not worth the public will. So that's all possible. But it is up to the prosecutors to determine whether they want to bring those again. Evil Bunny 7603 question, did I miss? Did they say what was wrong with them? Are you talking about the jury? If you're talking about the juror that left, I don't know. I don't know what happened there. None of us, we probably won't know. Pule and Ivis, thanks for the super chat. I once was flying back from Europe and watched Runaway Jury, the film, arrived to a jury duty summons. Oh, that is so funny. That is really funny. Way to get yourself in the mood. Alrighty here. Okay. Janet G, Legalbytes, do you think Lally saw the holes in his case, but maybe still needed to go forward with this case? I have a feeling that there may have been some discussions behind the scenes, like long before trial, that they were like, well, this case sucks, but we're in too deep. That's complete speculation on my part. So like, take that with a grain of salt. It's really not based on any information. So, Splits personality question. Do you think the perspective on this case would be different if we didn't get testimony from the crash daddies? They seem to seal the deal. I think they seem to seal the deal, but it just made the case stronger for the defense, in my opinion. It didn't turn the case for me. It had already been turned with Trooper Paul's testimony, particularly, but also Trooper Proctor's, and also earlier on, talking about the actual investigation quality. So yeah. Righty. Also, Sheena Ford, member for 1 month. Thanks so much for being a member for over a month. This chat is amazing. I agree. Folks are awesome in this chat. A-OK. Question, can you speak to what is a mistrial specifically? Well, I already talked about that. It's when there's a determination that they cannot come to a conclusion that is going to be fair and just for one reason or another. It could be because some sort of information came out that was so damaging that the jury has basically been spoiled by it. It has to be really, really bad for that to happen. Then or a hung jury is another way that you can reach a mistrial. Sue B, question, how many jurors were there coming in today? There were 15. There were 15 at the very beginning. One was excused earlier in the day. We don't know why. Dionysia Jaclo, Legalbytes, if found guilty. Haas, many years you think she will have? It depends on which one. So, I was talking about this earlier, but second degree murder is 15 years minimum, 15 years to life. Manslaughter while operating under the influence of alcohol or drugs is 5 to 20 years. And those can add on to each other. So it could be 15 years to life plus another 20 years or 5 years or something in between those two. And then leaving the scene of a personal injury and death there's options. It's either 1 to 2.5 years in jail or house of correction, or 2.5 to 10 years in state prison. So there's a number of options there. But I mean, if she's convicted of murder, it's 15 years to life, which is very serious, obviously. James Gaines Classics. Surely a civil case would also need science data, and there's none that supports her hitting him. That's the thing that has me questioning whether or not the O'Keeffes should bring a civil case against her in this case. Normally, I'm like, default, it's going to happen. And, it's going to get litigated and maybe even go to trial. But at the very least, at the very least, we'll get to settlement negotiations, right? So yeah. In this case, though, I don't know that there's enough here even for a civil case. And I'm not just saying that because it's like click worthy to have that opinion or something. I genuinely, this is a difference of opinion than I have from my typical baseline for any kind of a case. Like for example, Alec Baldwin, regardless of whether he's convicted or not, lawsuits against him for the death of Helena Hutchins. Same thing with Hannah Gutierrez-Reed, the armorer on the Rust set. So it's liability, negligence or basic negligence or things like that it's so much easier to find liability in a civil case that it's it would be a default in a situation like this. But yeah, I don't know. We'll see. Janet G, Legalbytes, it would stink going through the entire duration of this trial as a juror and then just be dismissed prior to verdict deliberations. I agree. Tish, Legalbytes, can you summarize what happened during yesterday's hearing about the jury instruction? Oh no, I already got that one. Barco Vurer, question, would the state's attorney have offered a plea deal prior to closing arguments or after closing? More like prior, I suppose, if they wanted to. Stephen Horton, question, do lawyers go to acting classes? I think good trial lawyers should do some kind of acting classes. I've never done acting classes, but when I was in law school, I was in my law school's advocacy program. We had one of my favorite memories from law school was actually doing some of the advocacy program stuff, which was where we were doing like games, which involved a lot of acting out stuff and getting very comfortable with each other. And it was just a lot of like play, essentially, of being goofy and all kinds of stuff. It was really fun. It was a way to sort of like lighten yourself up and be able to put yourself in a state of mind to perform. And I loved that. I don't know that every advocacy program does that. Mine was particularly good, I think. Shout out to Professor Tracy McCormick at the University of Texas. She's awesome. And that was all her shtick. So, that we had that. I don't know what other law schools have, and I don't know what other lawyers do, but it would be beneficial to have some kind of acting experience or something similar. Ashley Pedicini, thanks so much for the super chat. Thank you for the coverage. My first time fully watching a trial with Scott Peterson and haven't done it since. Haas, do I become a Bike Club member? Oh, thank you so much. So if you go, well, if you don't see a join button near somewhere around this screen here, it depends on the device that you're on. Some of them have it, some of them don't. There are links in the description below also to both the YouTube memberships and to Patreon. So whichever one you want to do. If you want emojis in the chat, for example, YouTube memberships is the way to go. If you don't care so much about that, but you want your name and credits at the end of uploads, Patreon is the way to go. Those two are kind of similar between the two. But otherwise, everybody gets to go to the members only live stream. Everybody gets early access to our non-trial recap uploads. And things like that. So either of those options are there for you. So also Hezo1 has got a link in the chat to the YouTube membership link. So thank you so much for that. Oh, yes. Oh, Elborite, thank you for letting me know. It says still jury instructions. So we can definitely just unpin that. Okay. All right. Okay, moving on down the line here. Dayan Lujic. Question, can the opposing counsel object to what, if anything, said? Yes, objections can happen. Objections can definitely happen. But they are fairly rare. You want to be very, very careful about them, because if you are wrong or if you over object, that can also look very bad at you, or bad for you, I should say. So you definitely want to be right if you're going to go so far as to object in the middle of someone's opening statement or closing argument. Definitely don't do it just to throw someone off and like anything like that. It's looked upon as very unfavorably. But there are reasons. For example, if someone is arguing facts on evidence, that is something that is objectionable. In opening statements, if someone is arguing instead of talking about the evidence that they're going to see, that the jury is going to see, because there's no evidence yet in trial, there are, they can object to that in an opening statement. So there are some things that can be objected to. But like I said, you want to make sure that you're right if you're going to do it. Tish, Legalbytes, thoughts on Jackson reading from the paper? I wouldn't be surprised if he has strategies to learn his closing arguments. Did he not have time? Was it too important to take the risk? I think that he was very specific in the language that he used. And an hour-long oration is a lot to memorize. That is a lot to memorize. So I don't know. Some people have some very strong opinions about reading from a closing argument, or reading a closing argument, or even an opening statement as well. So, a lot of people do have some strong opinions. I don't, so long as it doesn't interfere with their ability to engage and connect with the jury. And to me, I think he still was engaging and connecting with them. If he was just reading without like looking up and kind of being performative about it, then I think that would have been an issue for him. But for him, no, like he still had a really great ability to connect with the jury. And Wings, Legalbytes, since defense is going first, does that mean they get rebuttal? No, that's the thing that's so strange. about this whole situation. It's very off-putting to me to have the state go second. Yeah, I don't know. It's weird. It's not common. Usually you go prosecution, defense, prosecution, rebuttal. So it's, I don't know. I don't like that procedure. The Lucian, Legalbytes, wait a minute. Third-party defense. Judge originally said defense couldn't use this unless they showed some evidence. Do you think judge found something credible to allow this? It seems like it, because they were allowed to argue it in closing arguments. Sue B, question, I might have missed this, but I find it odd the defense goes first. The prosecution usually splits up, right? Yes. Yes, it was odd, but it does happen. Ghost Owl, question, is applause inappropriate after closing argument? If you are in the courtroom, yes, you will absolutely get kicked out if you do. But on a live stream, we can get away with applause, with shouting, with cheering, with eating popcorn and things like that. We can be a little bit more relaxed when we're watching from over here. Rhinus, Legalbytes, if the light ain't broke, this case is a joke. Very true. Mirage Sunsets, Legalbytes, if the FBI investigation into Proctor results in him falsifying this case, can they reopen all the cases he's worked on that have had convictions? Sure. I'm sure there would be plenty of defense attorneys that would be asking some questions and filing some motions for their clients that have been previously convicted. Amanda Coburn, is there not some sort of conflict with having them in the audience since they are a part of the defense case of what happened, possibility of jury being intimidated by them being there? I mean, well, for one thing, it's actually very common for the lead investigator to be in the courtroom for closing arguments. But in this case, I understand what your proctor didn't want to be there. So yeah, witnesses can totally be there. They can be there at closing. Joseph Zalay, question, are the jurors required to deliberate and review for a certain amount of time? If they think not guilty from the start of deliberation, can they just call it a day and come back out? They are not required to spend any amount of time doing it. The judge or the instructions, the jury instructions, have some guidelines or preferred rules really for how the jury does it. But once they get into the deliberation room, it's really up to the jurors themselves to determine how they're going to go about it. Like the judge asked them not to pick straws, or not pick straws, but basically take a vote at the very beginning to see where people feel about it. But if they do, it's not necessarily like against the law for them to do that. The jury instructions say otherwise. They wouldn't be following the instructions, but sometimes it wouldn't surprise me if there were some jurors that did that anyway, just to see where people were feeling about things from the beginning. Rubber Duck 77. Legalbytes, thank you so much for your coverage of this case. You've been my main source of watching the testimony. Well, wonderful. I'm so happy. I'm thrilled that you've stuck with me throughout this trial. It's been great. Sue B, a question, do you think the timeline is to waste time? No, I think his timeline was actually helpful. That was probably one of the more helpful things for the prosecution in communicating with the jury. But it was maybe a little bit too efficient. And so he then circled back to kind of fill in everything else. I also think that if you're going to use a timeline, you want to generally stick to that timeline to help organize all of your closing argument, rather than have a timeline for like the very beginning and then spend the rest of your time lally-ooping around to talk about a lot of the same details or other details that fit into the other parts of the timeline. Hey, puppy bear. Hi, sweetie. Christina Kirschner, question, why couldn't Jackson withhold part of his time for a closing rebuttal like prosecution does when they go first in other states? Because typically, the reason why the prosecution goes first is, I don't know, the reasoning here was just so strange. So typically the reasoning is prosecution goes first because they are the ones that have the burden of proof, and therefore they can reserve a little bit of time for rebuttal. But here it was the same reasoning, but that's why they go second. So I don't, it's strange to me that's, I don't know if that's just how they do it in Massachusetts in general, or if that's just what they decided here instead. So yeah, I don't know. It's very strange. If like I said, it feels weird. Crazy Kleins, Legalbytes, obviously anti-Bev granted CW the consciousness of guilt moving car, but I thought it had to be admitted into evidence to be argued in closing. Well, it technically was admitted into evidence. I mean, everything that they were referring to was testimony that came out, right? I mean, we know that she in fact went to her house and then went to her parents' house after going to John O'Keefe's house, which was after her going to the hospital. So that technically was in evidence. That's just an argument that they are allowed to make based on the evidence that came in. So that's why that came out, basically. Supposed personality question in terms of quality. Do you think Lally's closing was better or worse or equal to his opening statements? I think that his closing was a little bit better than his opening because of the fact that he actually made use of visuals for a time. He actually had a timeline that was up on the screen that was visual that people could actually track and follow. Didn't quite make it though, because it, like I said, it filled the beginning part and then the rest was just the Lally-oop. Mirage Sunsets. Legalbytes, if someone can prove Lally is part of this cover-up, can he be disbarred? Yeah, potentially. That's something that could disbar someone if someone is, truly found to be so. Abby the Dragon question. So I just thought of this with the Apple Health data. I don't recall the last time my health app recorded a drive as walking up or down 3 flights of stairs. I think the jury notices that. If they have their own experiences with Apple Health data, they are well within their rights to bring that in and say, that's never happened to me. My Apple Health data has always been super accurate. Or likewise, the inverse can be true too, whereas someone says, actually, my Apple Health data has lied to me quite a bit. And so I don't trust it. Either one of those is a possibility. Yep, that was me. Thanks for the super chat. Do you think Jen McCabe and them showed up to keep Turtle Boy out of the courtroom on the last day, like it happened when they testified, order of protection? It's possible. Could be. I mean, the whole reason, the reason why it kicked him out before is because they were testifying and they were supposed to be there. So there was that. So I don't know how that works where they're not there for the purpose of testifying, but they're there to listen. But that could be one of the reasons why. But Turtle Boy was there is what people are saying. So yeah, so then that was definitely just limited to their testimony. Mary Eller question: did anyone testify on how long it would have taken for his body temperature to drop in the weather? If he was really out there since 12:30, would his body temperature be lower? No one testified to that, actually. Yeah, there was no testimony about like how long it would take for various things to drop, and I don't know if that can be measured, to be honest. I don't know. Coles, Legalbytes, did we ever get the actual answer to the age-old question, how long to die in cold? We never did. Apparently Jen McCabe got a search result, but we never saw the answer. Jonathan Willig, question, did Lally say more names in opening or closing? I honestly don't know, because the opening statement in particular was like a wave of data and information and facts that I could not possibly have retained. I was even trying at the beginning to like write down names and things. And at a certain point, I definitely gave up, because I was like, I'm never gonna remember these people. Like who are these people? Like, am I going to go back and like really remember? I don't know. So I really don't know whether there are more in the beginning or in the end. Hawkwin, Legalbytes, seriously, I don't see a lot to deliberate about here. Your opinion. There are quite a few lesser included offenses. So I can see them needing some time to go through those, even just point by point. even if they all agree that she is not guilty, for example. Content in 1979, Legalbytes question, are there no repercussions for making stuff up in closing? There usually are. Usually, I mean, if there is an objection, you can have an objection sustained if it's, objection, facts, not in evidence, which that could have, particularly for the whole Karen Reed showed up to 34 Fairview Road around 5:18-ish, between 5:18 and 5:34, like that, I think could have potentially been objected to because of the fact that there literally is no data saying that. There was no evidence that came out other than his conjecture about her taking her time to get from the Waterfall Bar and Grill to Jen McCabe's house. Majufi question, do you think anyone from the O'Keefe family has changed their minds? I don't know what they would have started at if they, I'm assuming you mean, do you think that any of them have now think that Karen Reed is not guilty based on the fact that they had the Alberts and the McCabe sitting with them, sitting behind them? I doubt that. Desiree Bullock, Legalbytes question, can the jury take notes during closing argument? I would not remember to check the timestamp on the recordings Jackson referred to. The judge asked them not to take notes because of the fact that the purpose of taking notes is to remember their thoughts about the evidence, and closing arguments are not evidence. So the judge instructed them not to take notes during that time. I also don't think that I would have remembered the timestamp without taking down notes either. But I also definitely wouldn't remember Lally's closing without being able to take notes. Megan Rose, Legalbytes, I'll try and find a track of the What If Any's to tune of Macarena if I can. That way, no copyright. Oh, that's so funny. Caitlin, Legalbytes, if somehow she was found guilty, but the FBI found a ton of corruption and misconduct, including the DA's office, that could be used in appeal, right? Yeah, it could. That could. I definitely think so. Let me just check here. Okay. I wasn't sure if there was anything new from inside the courtroom. Sounds like not. Desiree Morgan, thanks for the super chat. Question in closing. AJ mentioned the CW has a responsibility to bring the truth. What would happen if CW would change their stance throughout the trial? Well, that can be flagged at closing as them moving the goalposts. And, and the jury might also just independently see that and decide you guys are lying to us and we don't like that. Nick Wilson, Legalbytes, has our suspicious trouble causing mischief making Hardy behind this bad investigation? You are referring to Lawyers and Dragons, and I love it. I don't know. Maybe Hardy the cat has been involved. Mew Mew question, a genuine question. Legalbytes, are you allowed to lie / make up things on the closing arguments? No, you're supposed to use the facts that are actually admitted in evidence. His Marca question, I thought it wasn't permissible to present new facts not in evidence during closing arguments. So, yeah. So, remember the part about the dimples on the taillight piece, technically that is in evidence. So talking about that is in evidence. It's the thing that is new is the idea that somehow those caused the abrasions to the arm, when literally no one testified to that. It wasn't anyone's opinion. So, yeah. A-OK, Legalbytes, thanks for dropping all the knowledge about this trial. Really appreciate this trial coverage. I'm from Mass, so it was nice to hear a non-biased opinion. My first time on your channel. Well, welcome. Thank you so much. Very, very kind of you to say. And I hope you stick around for a bit afterwards. Ray Lawson, question, if Karen is found innocent, can the judge advise that McAlberts and police be investigated? It wouldn't be the the judge. It would be some other investigative authority that would just decide to look into them, most likely. Life on makeup. Question, I wouldn't have allowed non-family witnesses to sit with the family because I feel like it could influence the jury. Why is this allowed? It is at the request of the family, though. So it's hard to tell them no. Sue B, question, why can't jurors share notes? Because the notes technically are not evidence. And the notes technically aren't the thoughts of the jurors. They are past thoughts, perhaps, of the jurors. They can also have mistakes. So the jurors can't share notes. You know, they can't just swap notes and say this is what happened because maybe they have mistakes in them. They're technically supposed to rely on their own memories. The notes are just supposed to help themselves with their memories. Sue B, Legalbytes. I feel like the jury will need the day to decompress. They must be bursting, having held all this in for so long. I would agree. I would agree. I think that they probably would just want to spend the first hour just talking about like what the F happened in this trial. And maybe it just naturally goes to like all kinds of discussion. I don't know. But yeah, we'll see. We'll see how long it takes them. Firefly Bakery Sweets. Question, I haven't heard of the Black Swan case. What is that one? So that one is out of Florida. It is a husband and wife. The husband is the victim in the case, alleged victim in the case. The defendant is on trial for murdering him. She shot him and she says that it was in self-defense. But the detail that is weird for the defense perspective is she shot him, she says, in self-defense in the back. How does one shoot someone in self-defense when the other person's back is turned to them is another question. Do they have some sort of a theory that explains it? I am very interested in that. But yeah, so that one is a very, very interesting one that is coming up next month, either the 22nd or the 29th. I've got to double check, like I said before. So yeah, that's another intriguing one. Lena the Conqueror. Question, I thought the prosecution said they weren't pursuing the lesser charge. I thought so too. Very strange. The Lucian, a Legalbytes question. Lots of talk about the charges. Can you lay them out and explain them? Ooh. Well, okay, so there's three main charges. There's second-degree murder, and then there's manslaughter while operating under the influence of alcohol or drugs. So in other words, it's like DUI manslaughter. Then within that, there are some lesser includeds, which is one of them is involuntary manslaughter due to wanton or reckless behavior. So in other words, it's a recklessness as opposed to so manslaughter while operating a vehicle while impaired, right? That one has intent. Like you have to have intended to do something and you're under the influence, intended to harm someone, intended to kill someone, and you end up killing them. The lesser included of involuntary manslaughter is there's no intent, but you were being reckless. So they have to show that you knew that there was a risk of doing something, you disregarded that risk and acted anyway, and you ended up killing someone in the process, and you were drunk. Then there's motor vehicle homicide, which does not require intent like manslaughter, and it does not require recklessness, but mere negligence can do it. So in other words, you're not acting like a reasonable person. You're not acting with the duty of care that a reasonable person would have. You are either doing something that a reasonable person would not do, or you're not doing something that a reasonable person would affirmatively do under the circumstances. So that's the motor vehicle homicide, lesser included for the whole manslaughter DUI charge. And then there is the leaving the scene of personal injury and death, which basically means, you were at the scene of where somebody, had a personal injury or they died. You had some responsibility involved in it, and you left with the intent to either avoid detection or avoid punishment somehow. That's the three charges in a nutshell. Oh, and also second-degree murder. I didn't really explain that one, but second-degree murder is basically where the defendant has intended to kill, They don't necessarily need malice aforethought. They don't necessarily need a motive. Second degree murder is you intended to kill someone or harm someone. You ended up harming them, killing them. And there was no legal justification for doing it. Dr. Who 8675309, Aunt Bev kept mentioning reasonable person. Is that reasonable for everywhere else or reasonable for Canton? I feel like reasonable for Canton requires 5 drinks minimum. I would think so too. There are actually circumstances where a reasonable person can be defined by a particular demographic. For example, in some like police officer lawsuits, right? Sometimes the question will be, what would a reasonable police officer do under the circumstances? And is this what a reasonable police officer would do? As opposed to a reasonable generalized person out there in the universe. So there are some circumstances where that is the analysis, but here it is a generalized reasonable person, not a Canton reasonable person. Michael Peterson, a question: have any in this trial been on a polygraph? I don't know. There hasn't been any testimony to suggest that. I wouldn't know about any sort of background information on that. However, either way, it would not be admissible because polygraphs are considered, as far as courts are concerned, they are considered junk science. They are not reliable enough for to be admitted as any kind of evidence. Ardo Risnan, question, Legalbytes, what was the total number of what if any's I need to know? So I talked about this earlier in the stream at the beginning, that there was, let me see here. Okay. I still have to work with this, by the way. Okay. So on day 29, there was 19. And then on day 30, if I remember correctly, there was 5. So between days 29 and 30, there were 24. And then before that point, there were 1993. So I have to do the math again. 2017 total. However, the last couple of days, I've got to go through and parse through which ones were Lally and which ones were other people, because there was a bit of a mix. So yeah. Megan Nelson, Legalbytes. I know this may change state to state, but will the alternates get a break from jury duty before they can be called for duty again? That actually, so even if they were called for jury duty and they got through only as far as the jury selection process and they were excused at that point, they have fulfilled their jury duty service for, whatever period of time until the next round that they would be called. So it's not like they can be called like immediately afterwards. Even if they've just gone through jury selection, generally speaking. Sue B, question, I missed this. Are the alternates sitting in the jury room or just have to keep away from media, etc.? Different courts do it differently. I've seen some where they will have them sitting and hanging out and they'll just keep them occupied. Like in the Rittenhouse trial, for example, they did Jeopardy with the alternates. Like the judge played Jeopardy, like some sort of a version of that game with them. And I remember when I had occasion to ask Natalie Wisco, who is an attorney that was on the defense team, whether or not they were allowed to participate in the game. She said, no, we were not. Unfortunately, we really wanted to, but we were not allowed to. So, sometimes they'll do stuff like that, but other times they'll just let them go home. Trudy Ann Barker, question, do we know if any person in the jury has any connections to the police? I don't know that. The parties would know, the judge would know, but I don't know that because we have not been given any public information about anything about these jurors other than what has been observable by the people who are in the courtrooms after they were impaneled. So, in terms of their connections to anyone, I don't know. That has not been publicly put out there. Dionyse Duclos, Legalbytes, do we know Haas many years if found guilty for all charges? We went through that before. So I will pass on that one since we answered that question already. Beyond the Bow, thanks so much for the super chat. Legalbytes, will you go live once the verdict is reached? Yes. Even if I cut this stream off and we go off because we're finished with all questions and everything, and then we get word that there will be a verdict, I will immediately go on and fire up a live stream, send out a blast of social media. So yes, definitely expect as soon as you hear about a jury verdict, come right back here. We will be live streaming it. We will be covering it. So yes, absolutely. Thank you for that question. Hawkwind, Legalbytes. People seem to want her to be guilty because of Turtle Boy's involvement. Is that as disturbing as anyone else as it is to me to use a personal grudge to decide guilt? Yeah, it's not a good reason to find someone guilty of a crime. Not liking someone else who is involved in the case. It is human nature, but once again, that is why you pick a jury that is not familiar with the details of the case, that don't have an opinion on anything related to the case. So that's why we go through that jury selection process, right? Is to make sure that people haven't been forming opinions for the wrong reasons. Doctor Who 8675309. Legalbytes, I am a firm believer in turning up the jury to 11. It was proven scientifically by Spinal Tap. Sometimes you have to turn it up to 11 for the best show. Yes, because this one goes to 11. Great movie reference. Very much love that. If in case you guys are not aware, that's from the movie. This is Spinal Tap. It's one of those mockumentaries made by Rob Reiner. It's really, really great. It's one of those very tongue-in-cheek, understated kind of mockumentary sort of movies. Very similar to Best in Show, same maker, and a number of others that are just hilarious. I love it. The awkwardness and the subtle humor just gets me every time. Heather S. Legalbytes, they said alts were still on call in case a juror has to leave and deliberations would have to start again if an alt came in. Yes, they did say that. So they don't, and that's why they said that they don't want them talking to anyone about the case even still, which is even more infuriating. I would hate to be an alternate and that's under those circumstances, because at least the people who are on the jury are allowed to talk about it with each other. But now somebody who's an alternate can't talk about it until the conclusion has actually been reached. Then they're free to talk about it. But otherwise they have to go home and not talk about the case at all. That would be very, very frustrating to me. Mac Legalbytes question: did they explain why Karen left him voicemails asking where he was 20 minutes after she dropped him off herself at the Alberts? That's the only thing I can't make sense of. I mean, neither side really has a specific explanation for that. The prosecution basically just says, well, the defense says that she's just like, she's peeved. Like, what was it? What did Jackson say about those voicemails? He said she's perturbed, then she's peeved, and then she's pissed. And so she basically it's this wind up that she's done with herself because of the fact that he's not responding to her. That's their general explanation for the voicemails. The prosecution's general explanation for the voicemails is that she's angry at him for what she thinks is cheating on her, and she's still angry at him for what she says is cheating on her. I don't know how that fits with her saying, "Where are you?" If she knew where he was. It seems like they're also suggesting that she's covering her tracks by saying that. I don't know how someone can be in that state and think logically enough to cover their tracks, though. To me, it doesn't make that much sense if you think about just basic human psychology. Legalbytes, what or who, if anyone, is the FBI investigating? I think I answered this one before. Basically, my understanding is they're investigating the investigation itself. I'll kind of leave it at that. Mac, question: why do you think Karen left him voicemails? Oh, wait. I already got this one. I just did. Okay. Jerry Roth, Legalbytes, how long do the cats deliberate about being fed? In all seriousness, what are the odds of a hung jury? Well, the cats don't need to deliberate because they generally have free access to kibble that is out of Indy's reach. So it's easy for them. Indy, on the other hand, is on a scheduled diet because otherwise she would vacuum everything and she would be the size of an actual house. So yes, they don't need to deliberate about that. The odds of a hung jury, I don't think they're that high in this case. I think there are a lot of people that have been watching that think that there's a high likelihood of a hung jury. I don't think so. I think that they're going to be able to come to a conclusion. I mean, maybe I'll change my mind in a couple days if it's still going on and they haven't reached a conclusion, but that's what I think now at this point. Logan, Legalbytes, could the selected foreperson turn down that role? Maybe not to the judge, because she didn't really give an option for them to turn it down. But in the jury room, they might say, I don't actually want to be the foreperson. And then someone else can sort of de facto step in. I can see that happening. Letitia made this question. Is it a possibility that the jury acquits on everything because they're so angry at Proctor and his handling? REOWI. Yes, absolutely. Absolutely, they can. The Black Pope, can I hit him be seen as enough evidence? Can the I hit him be seen as enough evidence? If the jury thinks so, they could decide that. They could decide that. Cheryl Flores, Legalbytes, is it a win for Lally if she is convicted on the alcohol charge? I think it's a win for Lally if she's convicted on any of the charges. I don't think that she should be convicted on any of them. But I think that would definitely be a win. Mr. Waffles, question, what is your opinion now that you've heard closing arguments? How did they hold up to what the opening statements promised? I think the defense definitely kept their promises much better than the prosecution did. The prosecution still has too many questions that went unanswered as to what their actual theory is of how it happened, how Karen Reed's car hit John O'Keefe and killed him. They're just that's still unanswered at this point. And even the closing arguments didn't answer it. He didn't provide a theory of like what actually happened to get him to the place where he was found. The defense, however, did a much better job of going through and showing how they think that Karen Reed was framed. And, whether you believe it or not, they at least put their theory on, and it was with evidence that came out at trial. So, that's what I think. Has one Legalbytes, that clip would be great for your recap video. Oh, which one? Shoot. Is it the 84 years? Let me know, One, if you're, you are still here. Let me know if that's the one that you mean. I'll look in the YouTube chat for that one. Buttercup 203 question, how will we hear from you when verdict is in? Social media. So if you guys are following, the bridesmaids clip. Okay. Yes. That would be funny. So how to hear from me, when the verdict is in. Twitter, community posts. Those will be my first two places. I will also put on the Facebook page and Instagram account and Patreon. So I'll put a social media push on all of those platforms. So there should be something. So, if you guys are just following on YouTube, community posts will be it. If you have notifications on, then you should be able to see the you should be able to see the community post notified if you have all notifications on. Alrighty. Beyond the Bow, Legalbytes, will you go live when the verdict is reached? Yes. I answered that one for sure. Bluebell, Alita, I might have missed this. Did we get a final alley tally for what, if anything? Oh, I talked about this a couple times now too. So it's not final, but the tentative final is 2017. It'll probably be a little bit less than that, but definitely over 2000. Logan, another question. Sorry, LOL. No worries. No apologies for the questions. Do you have thoughts on this trial being referred to as a cover-up trial? It affected my perspective subtly as someone who was unfamiliar with the case. For me, I was skeptical. It was one of those things that it kind of took me back a little bit when I heard it referred to as like a cover-up trial, Karen Reed is framed, all of that kind of stuff. So like I was very skeptical because it's such a bold claim. It is such a bold claim, and you really need good evidence in order to back it up, right? Like you definitely need the receipts for it. So I wasn't certain, like in my initial appearance, like into, or not appearance, my initial sort of digging into the case. I was like, is there enough there for it? Okay, maybe this, maybe that, but like, what about what the other side says, right? What about the evidence that shows in the other direction? So I really was very skeptical of such a dramatic kind of claim that it kind of like pushed me back from it a little bit. But as we continued watching, and I was like, hey, there's actually some meat there. There's actually some reality that underpins these arguments. So yeah. Gemma Noon, question for everyone. Am I the only person who thought that Lally describing the snow as a blizzard was hilarious, or am I reacting in Albertan because I thought visibility was pretty good? That definitely, and that's the thing too, is that it's going to depend on, what the jurors have lived through, right? Because I'm from California. I don't necessarily know. I don't think I've ever been in a blizzard. I'm pretty sure I've never been in a blizzard. Snowstorm, sure, but never an actual blizzard. So I wouldn't necessarily know the distinction, but someone who's from Alberta probably would have some major thoughts. Someone who's, from like a bit further north in the United States should have thoughts. Massachusetts, I would think, would know what a blizzard looks like. So the people who are on the jury may be thinking along your lines, or they may be thinking along the lines of like, oh yeah, that did kind of seem to be a blizzard. VS question, but don't all charges to be considered involve the car? So if jurors don't believe the car hit him, then not guilty at all. Exactly. That's why Trooper Paul's testimony was so bad for the defense, for the prosecution. So good for the defense, really, because they don't have enough, in my opinion anyway, to show that the car actually hit him and caused him those injuries. There's not enough for the medical examiner's testimonies, 2 of them, right? Or Dr. Frank Sheridan from the defense side. None of the medical experts can get you there. None of the accident reconstructionists can get you there unless you are willing to trust the broness of the trust me bro of Trooper Proctor's testimony. That's the only way that you can get there to get guilty on all of these things. Because, you have to look at the reality of like this stuff being physically possible at the same time as Karen Read making these statements. Because, you can also look at it from that angle too, and say, this isn't physically possible, but then how do we explain the statements that she made? Then you look back and you look at things from another perspective and say, okay, but is there a possibility that she said those things and it didn't actually connect to the reality of what was going on in her brain? I think so. Absolutely. And that was my thought before we even got to whether or not this was physically possible. So if the accident reconstructionist on the prosecution side had been way stronger, if they had provided a theory that actually made a lot of sense, that could have made me rethink how I looked at Karen Read's statements. Could have, possibly. But because it was so weak, I was like, no way. I'm still way back with Karen Read lost her mind, and like everything that she was saying was just completely disconnected from reality. And, she was just saying things that don't make sense, along with the Jen, Carrie, in a way that was completely, I don't know if this is the accurate word for it. So please, folks in the chat or on replay, who are, very intimately connected with mental health professions, I don't know if this is accurate. So please don't come at me too hard, but it seemed to me manic. Like that would be my description of it as a lay person who's not involved in that kind of a field. But to me, it seemed manic. If there's a better description for it, let me know. But like, yeah, it's just, it seemed like she did not have a grasp on reality in those moments. So I don't know. But yeah, anyway, but back to your question. Yes, if you cannot hang your hat on Karen Reed's car caused the injuries to John O'Keefe and John O'Keefe's body caused the damage to Karen Reed's car. If you cannot connect those two, you can't get guilty on any of these charges. Oh yeah. Jillian Spagnotta, manic or nervous breakdown. I would agree with that. Nervous breakdown. I definitely would agree with that too. Rebecca Farrison, question, can Karen bring a case against the state for wrongful prosecution? It would take a lot. It would take a lot. More likely would be a claim against Trooper Proctor personally for public disclosure of private information. I've talked about that before. Mary Herbie, Legalbytes, what are your thoughts on the judge? Was she biased or fair? There were some decisions that she made that I disagreed with, but I think on the whole, I think that she was, most of her decisions I think were okay, you know, but I think that there were a few that I didn't agree with, at least. James Randolph, how is it's pronounced Alita. So like not a pint, but Alita. That should help you remember it. Thanks, James Randolph, for the question on that. Blue Bell, Legalbytes, I may have missed this. Did we get a final Lally tally on what, if anything? Also, thank you for all your hard work. You're very welcome. Thank you so much for joining for it. The tentative tally right now is 2017 before today. So, but that probably is going to get discounted by a bit. Also, Heather, this is helpful. Manic, the defining characteristic of mania are increased talkativeness, rapid speech, decreased need for sleep, racing thoughts, distractibility, increase in goal-directed activity, and psychomotor agitation. Not really Karen. She's panic and shock to me. I don't know, but a lot of that seems to describe her like when she's trying to give CPR, she like does a little bit and then starts like running around, for example. I don't know. But you know, if it doesn't fit, it doesn't fit. But there's a lot of that does seem to fit to me. But yeah. Major question: what grounds for appeal do you think they have if this goes sideways? There were a number of things that I remember saying were potential reversible error, and that the defense could put in their pocket for an appeal. But I can't remember off the top of my head at this hour. So there were a number of things. Brittany Pratt, question, Legalbytes, what were your thoughts about Lally putting in the wrong tow truck pickup time from Dighton in his closing arguments? I was flabbergasted, and clearly Karen was too. Yeah, a lot of the dates and times have been floating around from the prosecution side, and that's, if the jury catches that, then that's going to be very damaging to the prosecution. Jury can be like, you guys are lying to us and lying to us again, even in the closing argument. Only Cops, thank you so much for becoming a YouTube member. Welcome. Such a funny name. Welcome to Bike Club. So happy to have you here. And thank you so much for supporting the channel, helping to keep the lights on. William Powers, Legalbytes, any opinion on length of jury deliberations? I think I don't see it happening before the end of the day today. Maybe at the end of tomorrow, I could see that happening. Before lunch tomorrow would be fast, in my opinion. So I would be content with just kind of sitting tight. Jessica Freitag, question, when is Baby Bites due? I'm due August 5th and over it. How are you feeling? I am due in September. So I am not quite over it, but I am getting into that stage where things are just getting harder, sleep gets interrupted more often, and it's harder to stay comfortable sometimes. And thank goodness I actually have a very good ergonomic chair. And I'm not saying this because, well, it was because of a sponsorship. So the sponsorship was from one of my videos right before starting this trial. But like they gave the chair as part of the benefit. And I genuinely have been enjoying it. It's been very, very helpful for these long streams and whatnot. But yeah, I'm not quite there, but but I'm sure I'll be there soon in terms of being over it. But also congratulations to you in advance. So hopefully everything goes well for you. August 5th it's around the corner. So that's gonna be quite a while, quite a wild ride, right? MC, thank you so much for becoming a YouTube member. Welcome to Bike Club. Thank you also for supporting the channel. Really helping to make this channel an even better place. I love it. Sandra, question: any opinion on the outcome outside the courthouse if they say she is guilty? The outcome outside the courthouse. I'm not sure exactly what you mean. Do you mean like what might happen in terms of like the crowds and stuff outside the courtroom? Because that would be, I would expect, I don't know. There's obviously been a lot of tensions that have been rising in the area. So I would hope that people are at least peaceful. Also, MC, thank you for not just buying a membership for yourself, but now gifting 5 Legalbytes memberships to other people. That's really awesome. Very kind and generous of you to bring in more people. Emma Lisa 4, Amber Hamilton, D. Mar, Leah Simpson, Nebraska Jeff. You have all been gifted memberships by MC. So welcome back to Bike Club. So happy to have you guys here as well. But yes, welcome. And thank you once again to MC. Sandra, question: any opinion on the outcome? Oh wait, we just asked this one. Travis James, question: how long was the Rittenhouse verdict? That one was days. That one had gotten to like 3 days, 4 days, if I remember correctly. It felt long. It definitely felt long. To a point where like it was like every time there was a question that came back from the jury, we were like sitting and analyzing like what could this possibly mean, and like what kind of dynamics, what are they really, the only thing that you can conclude from jury questions is what the jury is actually focusing on. So that's always interesting when something comes back and there's something about, they asked this, they asked that. And if I'm not streaming when there is a jury question that comes in, I will almost definitely be tweeting about it. So I might also post on the community tab on YouTube as well, but definitely I should be tweeting about it. That's where I'm more likely to put some faster thoughts on the trial. Also memes from the trial. So if you aren't following me on Twitter, that's a good place to follow me as well for that kind of stuff. But like, anytime there was a question, really the only thing that you can conclude from that is like, what are they focusing on at the moment? Sometimes that can indicate maybe they're looking towards guilt, maybe they're looking towards acquittal, but you have to be careful when coming to a conclusion like that. Some people get very, very shoot from the hip on those kinds of conclusions, and it can end up making them look a little bit foolish when the ultimate verdict does come in. So you got to be careful about that kind of stuff, but it's always interesting to kind of sit and speculate for a little bit. Queensy, Legalbytes, what do you think about Lally using the kids' names also on the screen? I hate it. I absolutely hate it. I didn't say it during the stream, but I probably should have, because yeah, I very much do not like the fact that their names on the jury or on the witness list are redacted because they're minors. They're minors. There was a reason why their testimony was not televised. So there should be a level of protection for them. Granted, oh my gosh, Indy. Hi, puppy. Granted, reporting has already, like, people have known who like their names anyway, based on like what's been reported and whatnot, I'm pretty sure. But like, if you're the prosecution and you're saying that you need to maintain protection, media can't have cameras in the courtroom during this period of time because they're minors, like, you should be also held to that standard by not using their first full names, by using their initials instead. And it's just, it's really infuriating that they didn't, because it means that they don't really believe in actually maintaining their confidentiality. And yeah, Jillian Spinoza, he also used their full names when questioning other witnesses. Maybe it was just a slip up, but he did it so many times that, in my opinion, I think that it was, well, and also it was written on like the actual timeline that was put in front of the jury at the end during closing arguments. So like, that's not just like you happen to say something that's in your brain. There's a process of making those demonstratives for the closing argument, that, the fact that it was actually written in their first full names, I think it speaks to the fact that they just don't care to actually maintain the confidentiality. Mr. Waffles, Legalbytes. To me, it's so weird. Did the prosecution argue KR was so drunk, 7+ drinks, but had the state of mind to fake an alibi with the messages and calls? Yeah, she's a really good drunk, isn't she? Apparently, according to the prosecution. Yeah. But of course, we don't know. He didn't even say how many of those drinks had shots in them, for example. How many of those drinks had, like, that we can really say for sure. He was like, well, we have the receipts. We have a receipt for a $10 charge from McCarthy's. We don't have a receipt for her, or sorry, a $50 charge. We have a $50 receipt for her and a $50 receipt for John O'Keefe. And like, that's about it. Yeah, you guys, this camera's, it's gone rogue. It's totally gone rogue. I have no idea how to control that. This is a brand new feature that is absolutely hilarious, but I kind of love it because every time she moves and she does something that's kind of cute, the camera like zooms in on her again. So I'm fine with it. Albert was there to intimidate. He gave me uneasy, creepy feelings. Yeah, I mean, maybe, yeah. I can see that. They want a show of strength, of power, perhaps. That can make a juror feel one way or another. Jen Bizesto, Legalbytes, did you see the assault of Turtle Boy from the other day outside of the pizza house in Canton? I saw something about it. I haven't seen the details. So I'm sure you can get plenty of good information from like Twitter and elsewhere on that. I unfortunately haven't had a chance to really be able to really look into it enough to be able to comment on it. Coffee Star 62 question: can they ask a question to the judge or lawyers? Yes, generally speaking, it's to the judge. It's going to be something about, can we talk about, or can we look at this, or can we look at that, or what does this mean in the jury instructions? That's the kind of stuff that typically comes back as questions. Let me see really quick something here. Okay, so far nothing from the jury deliberations. No news from there. Just wanted to check really quick. But yes, they can ask questions. Absolutely. Dogbite, Legalbytes, can Karen sue the state police? Possibly. Generally speaking, no. There may be some potential claims. I haven't spent too much time thinking about that, to be honest with you. Evan Les Thagi. I mean, but generally speaking, so let me back that up really quick and say, generally speaking, you can't sue the state unless there is permission that has been given to sue the state, if that makes any sense. There's something called sovereign immunity. It's the 11th Amendment. So you can't sue the government for any old thing. It's because we have a political process to enact change when you don't like what the government is doing. However, there are some circumstances in which you can sue the police for things like, using excessive force in an arrest and things like that. There are some like constitutional violations you can sue for, but what was I going to say? But this particular case, I don't know. I would have to think about it. Sorry. Evan Les Thagi, Legalbytes, what's next for Karen Reed, and what's next for the John O'Keefe case if Karen is found not guilty? So next for Karen Reed depends on this verdict, very much so. Other than that, I don't know. I also don't have any background information, or behind the scenes information for what she would do next. She's got a lot of legal fees to pay, that's for sure. And what's next for the John O'Keefe case? I don't know. Maybe it goes back to the drawing board. If she's found not guilty, maybe it goes back to the drawing board and there's some other charges against someone else, or it just ends up staying where it stays. And that's also sad for the O'Keefe family. Karan, Legalbytes, what if any case will you cover live next? IJC, I love it here. Well, thank you so much. Wonderful to have you here. And I hope you do stick around for more. We're going to have more like smaller videos coming out this week, next week, however, until whenever. Then next month, there are 2 trials that are on my personal docket. We've got the Alec Baldwin trial and we've got the Black Swan murder trial. That's what people are calling it. She's a ballerina that killed her husband. The question is, was it murder or was it self-defense? So that was the Ashley Benefield trial out of Florida. So those 2 next month are coming up. I think I'll probably be able to cover both of them, which will be very interesting too. And in between, there's going to be all kinds of legal topics that we're going to be covering here and there in a lot of uploads and things like that. Erica Odell. On the voicemail, she mentioned you are probably with someone else now. Maybe that is why she asked, "Where are you now?" That's the defense's theory. She thinks he's stepping out on her. Megan Rose, thanks for the super chat. OMG, 3,000 plus votes on the poll. Yes, we do. We do over 3,000. So I'll leave that just a little bit longer. Noeline Byrne. Question, couldn't figure out what relevance the Jen butt dials were until final arguments. Is the defense saying Jen was looking for his phone? That is what they're saying. Evan Lestegi, question, Legalbytes, what's next for Karen Reed? Oh, I already answered that. Looks like that was sent in twice. Natalina Rose, Legalbytes, the defense said he never came back out and she was waiting for him and she left him there because he wasn't answering. The defense said he never came back out. And yes. Yeah, I think that's about right. Jeffrey Hoffman. Question, do you think she'll be found not guilty? Well, will she or won't she is a very hard question to answer. I think she should be found not guilty. But what the jurors are going to do, I don't know. I never know. I always hope that they agree with me because who wouldn't, right? But I think there's a good chance that she's found not guilty. But if she is found guilty, that will also be very interesting to look at what they may have, what actually convinced them that she was guilty. Arta Risnan, Legalbytes, question, why are lawyers so bad at math? It has been 112 years, not 84. You're such a jokester. Evan Lestegi, question, what's next for Legalbytes, or what's next for Karen Reed? Okay, already answered that one. I think I've sent it a few times. Dan Luyich, Legalbytes, I created an X account to tag you in a quick edited video of AJ Rapp in which I tagged you and was utterly shocked at what people are writing about this KR case. Yeah, there's a lot of intensity out on Twitter about it or on X. But thank you for tagging me in that. I will look for that and we'll definitely have to take a look. Logan, Legalbytes, does Indy have a Juris dog tour or just a good girl? Oh, she does have her Juris dog tour. She is a full-time pup squire. Sonia D, Legalbytes, what do you have on your camera that sometimes zooms in on Indy's face? We need more of that. So it's this. So what I use to live stream, what a lot of people use to live stream is StreamYard, which is an app that you download to your computer. And I had been using, so I actually have this other camera is actually it's an iPad. And so I've been using the browser on the iPad to connect this other camera and to be the IndyCam. So I'd been using the browser for so long, and earlier this week, or I guess on Monday, right after the morning stream ended, I exited out and then went to go, fire up the afternoon stream, and it told me, you now have to use the StreamYard app for this. And so I was like, okay, so I have to download the StreamYard app. I downloaded it, and then it had all of these weird features, and it's brand new. I haven't had a single minute to poke around with it to see what's going on. And if the zoom feature can be turned on or off, or if I can control where it zooms. But yeah, it's kind of wonky, but it's kind of funny how it's doing that on its own. So, hopefully I'll have a chance to figure out, a bit more on that and move on. But otherwise right now it's actually really funny. So I guess it's fine. Mildred Katie, thanks so much for the super chat. Will answers come out from the federal case? Perhaps, actually, perhaps. That is definitely a possibility. Doctor Who, 8675309, Legalbytes, my birthday is September 26th. Should you have baby bites on that date and it's a boy, will you name him after me? Well, we have a name picked out for baby bites already, but that's definitely take your shot on that one. Pat Guido question, isn't everyone missing the fact that if KR reversed for that far, she would have ran right into Hagen's Jeep that was parked in the mailbox? That's another thing. It's another thing. No one pointed it out on cross-examination, but that is something that we have definitely noticed as well. And in fact, when I had Brandy Churchwell from the 13th Juror on the channel on Sunday to talk about the case, we were talking about that together also. Dionysia Duclos, Legalbytes, can we go back to Menendez Bros Mondays? So yeah, this with trial being out, that leaves Mondays open for some live streaming. However, due to the nicheness of the Menendez brothers case, I've been putting a lot of thought into it, and the fact that like when monetization can, or not monetization, the viewership on something can be impacted by how popular something was before that came before a certain piece of content. So if you have a particular series of videos that you put out that are not getting picked up by viewers, that can impact monetization going down the line. So the fact that Menendez Mondays is so niche can actually harm the channel overall, the viewership overall of the channel. So all of that has me thinking I want to complete the project, because I hate going part way through a trial, even one that's like so long as that one. But I'm thinking that I'm probably going to be making it members only, because then it won't impact the viewership overall on the channel or anything like that. So that, anyway, I don't like, making something too exclusive, especially if people have been following along for a long time. And then all of a sudden, if they can't afford a membership, for example, that is something that I've really been going back and forth on. But I think in terms of like the business of the channel, I'm probably going to have that one turn to a members only feature. So yeah. Brian Stark, thanks for the super chat. Will we know if they request to view evidence? Probably. Usually that comes in a note that gets read to the attorneys. All right, Sophie Hill. Legalbytes, is there a proper legal process for the clear and obvious misconduct, shadiness, corruption of the police in this case to be formally investigated? I think that's what's going on now with the FBI investigation. So that would be one process. That's my understanding. Desiree Morgan question: do we know how long / what distance KR reversed? I think they said how many feet. I can't remember. He said it in his closing arguments. It was part of the text stream data, I guess, was how far she supposedly went. But I can't remember off the top of my head. Ella, thank you so much for becoming a new member. Welcome to Bike Club. Very happy to have you here. Thank you so much for supporting the channel. And like I said before, with others, helping to keep the lights on. Very, very thankful, very grateful for all of your support. Megan Rose question, Legalbytes, what was your favorite part of working with clients when you were practicing? My favorite part was getting a good result for people. That was definitely my favorite part, was when they had a problem, we could fix it, we were able to fix it, and then they could walk away. That was my favorite. When there were some situations that, like where a case just kind of took longer than anyone would like, it was always very frustrating because it was very stressful for the client and whatnot. But the ones that were most satisfying were the ones that we could get a fairly quick resolution for them, and and send them back on their way to live their lives. Ray Woodward, Legalbytes, can we look forward to any more Lawyers and Dragons? I love the humor of you all. Thank you so much. It's so much fun. It really depends on the guys putting it on. I am always game to join for Lawyers and Dragons. Most likely, I think what was most recently discussed is doing some more one-offs here and there as opposed to a full campaign, because that takes a lot more effort and energy and organization to put on a full campaign. And it can also be kind of hard to coordinate people's schedules over that long of a period of time. But, you know, doing a one-off on a weekend is like much easier. Okay. So folks are also saying it was probably like 62 feet, something like 60 feet. Okay. That's, I think that sounds about right. The Lucian, did you manage to watch the ASCA Industries video about the key cycles before the stream? No, I didn't, unfortunately. So yeah. Okay. Well, that's the last of the questions. So yeah, that's everything. We are totally caught up to all the questions and all the super chats. And thank you so much for joining me, you guys. This has been a really great stream overall. I am going to be continuing to monitor any and all updates from inside the courtroom. So let's see, what time is it now? It is like almost 3:30 p.m. So they might be going for another 30 minutes. I missed it. Did she say that they would go until 4 or 5 p.m.? I know that she said that she would send a note to them at the end of the day and ask if they wanted to continue deliberating or what. But I'll continue monitoring. I'll be posting updates. So follow me on Twitter, obviously here, subscribe, put the notification bells on. And then we'll fire up a stream as soon as we hear that there is a verdict that has been reached. I don't anticipate happening today, maybe by the end of tomorrow, possibly. Thursday is maybe a little bit more likely. So we will do that. Juror 13, what do you think of Lally stating that only J.O.'s DNA was found on his clothing? That's not what was presented. That also was not accurate because of the fact that there were 2 unidentified males that were also present, 2 or up to 3 or 4, I think, in some parts. So yeah, also an inaccuracy. So, okay, folks, once again, thank you so much for joining me on this crazy journey with this trial. We are almost wrapped up with our coverage of it, but that will be coming when we've got, a verdict coming in. So until then, we're going to be putting out some more content on other topics. So stay tuned for that. Thanks again to all the people who are in the chat, in the replay comments, all the people who are watching and lurking and just following along by audio with us as well. Thank you to the people who bought memberships, whether here on YouTube or on Patreon. I appreciate every single one of you, and also the super chats as well. And always, last but not least, the mods. Thank you so much for helping to make sure that this space is a great space for people to come in, bring their thoughts and their opinions, their diverging perspectives and whatnot, and how they see these things, because it can be totally different. That's why there are 12 people on a jury, is you can have people that are 12 different perspectives, and hopefully they can come to some kind of agreements on these various these various issues that come up in these trials. The final poll for today about how long until the jury reaches a verdict, we had 3,200 people voting. So 48% thought that there would be one by the end of today. 30% said after today, but by midday tomorrow. And then 13% said not until the end of the day tomorrow. 7% said not until Thursday or later. So we will see how that all goes. Very interesting polling there. And yeah, stay tuned for more stuff. We've got more trials coming up. Also, we've got more other interesting stuff, interesting stories as well. So, all right, folks, that for me about does it. Thank you so much once again, and I will see you in the next video.